Bom dia.
Good morning. Since we have the necessary quorum, I would like to declare open the internal commission to subsidize the elaboration of a minute necessary for the appraisal of the project of the bills 0.521 of 2020 and 872 of 2021, whose goal is establishing regulations and foundations for the regulation and development of artificial intelligence in Brazil. The present meeting is destined to carry out an international seminar to be divided as follows. According the schedule that's being handed over the participants, I will proceed to the opening words. Mr. Ricardo Vilas Boas Cova, President of this Commission, Mrs. Laura Scherter, Secretary of the works being held here, Mr. Members of the Juris Commission. Before my words, I would like to greet on behalf of Rodrigo Pacheco, who right now is in a meeting with the presidents of the Deputy Chamber and the Minister of States, taking important measures for our country. But he wanted me to transmit his very words for Minister Ricardo Vilas Boas Cueva and to all the members of this commission who deliberated the General Secretariat of the table, Minister Cuevas, the Administrative Act, which has 120 days for the functioning of this commission. So on behalf of our President Rodrigo Pacheco, who is right now carrying another seminar, to President Arthur Lira, since we have here in Brazil a bi-chamber system, that means the most absolute syntony, the most absolute tune of the works carried out in this commission with the other houses to debate and follow up the policies to be implemented in the area of artificial intelligence. These are the very words. And now I would like to greet everyone on behalf for our seminar. It's a great pleasure and an honor to be here today and to be part of another important step in this historical process, which pretty soon will result in a legal document of utmost importance for the life of our nation. It's undeniable the magnitude of the importance that the electronic resources had been acquiring in human lives all over the world, and especially in Brazil, where we estimate that there may be twice more digital devices among tablets, smartphones, notebooks, and desktops than people. In this context, artificial intelligence is an undeniable reality which enchants, and why not say at the same time, haunts us all. We dream with their wonders, we fear its power. Where will it go? How will a future full of thinking machines be? For far beyond science fiction, one thing is for certain. We can't take for granted a legal, robust background to support and sustain the human relations that will be subject to all this incredible technological development. Thus, it's no exaggeration, the affirmation that the works of this very commission will enter the story, will enter history. The importance of the legal document to be produced by the end of the works is only comparable to the expectation we have in the technological development to come. Under the presidency of Minister Cueva, this commission had developed a truly exemplary work, which will be as a template, as a model for similar groups in the future. After the publication of the theme axis of these works, this illustrious commission has opened several channels whereby society can send their contributions. Over the last few months, working meetings and all public audiences of multi-sectorial character will collect multidisciplinary subsidies of several sectors of society. This international seminar wraps up the second step of the information collection by the Commission. Hence, for the next few months, the members of this Commission will study to produce the final document to be presented by the competent reporter Laura Shurto. Thereby, we'd like to wish all participants of this event a fruitful development of the topics to be approached in such a way that we can embed to our legal background the best of international experience. We wish you all a great and fruitful work. Congratulations to everybody and thank you very much. Now, I would like to share the presence of the works to our President of the Commission, Minister Cueva. I would like to reiterate the greetings of Rodrigo Pacheco and the whole Federal Senate for the great functioning of this commission and for carrying out this important seminar. Thank you, everybody, and have a good day. Good morning, everybody. I would like to greet Senator Eduardo Gomes. I would like to ask him to the President of the Senate for the confirmation of the deadline for the presentation of our final works. I would like to greet on behalf of Professor Laura Scherto all the participants of the Juris Commission. I would like to greet all guests that are following us, they are with us either presentially or remotely. The debate on the regulation of artificial intelligence is something recurring worldwide due to the great ethical, legal, political, economic challenges that unfold with the unstoppable development of increasingly ubiquitous tools with regard to our databases. There is the fear that artificial intelligence is to unfold its forms, its autonomy, interdependence with regard to human beings, that such may bring, on the other hand, the lack of a legal milestone and the lack for the devices for artificial intelligence would be harmful. In Brazil, such a discussion has boosted since September 2021 with regard to the Deputy Chamber, the Bill number 21, which together with other three projects aim at regulating artificial intelligence in our country. The proposals from different sources had tried to discipline by and large and markedly psychological aspect with the aim at fostering trust and the implementation of its uses without resulting in discrimination or digital exclusion. In the project, there are three premises that are highlightable: providing and allowing to take international standards to allow good practices and technological development, centering technology in human being with respect to the digital. The text has been inspired in the proposal, which is ongoing in the European Parliament, with the following definition of the system of artificial intelligence as something that aims at reducing, and on one hand, the regulation that takes into account the subjects in context of the functioning of the system with the goal of avoiding excesses that hinder innovation. On the contrary of the European proposal, There are no absolute prohibitions foreseen or limitations before what's seen to be as artificial intelligence, given the risk to understand that the law or regulation or self-regulation, sectorial self-regulation, could follow up in maturity, the development of technology, and the usages and applications. In USA, we've borrowed the decentralized conception, which favors topic and subsidiary interventions in the public sphere with no need of consulting any customer for overseeing all artificial intelligence systems. According with the project, the civilian responsibility for the use of artificial intelligence tools is subjective with no consideration of the legal legislation or the complexity of the applications for artificial intelligence that may bring different conditions with not unreasonable. This text has been criticized by its rather psychologic ways and its vagueness with no differentiation that allow its application in concrete hypotheses. The regimen of civilian responsibility is perhaps the most criticized top part of the former project, where instead of careness and everything that's being shown in the European text, the text may render into interpretations that wouldn't have something to do with the civilian model, going against the international patterns, given the high degree of unpredictability and the development of artificial intelligence and its unfoldings, both in economy and interdependence of the system, it would be advisable, called, as the critics say, an obligatory insurance as part of the inherently dangerous activities that could help repairing damages. With those uncertainties in mind, the President of the Federal Senate has called a commission of jurists in order to subsidize the elaboration of the project that the Senate will prepare these bills already approved in the deputy chamber. In order to conclude with this goal, the deadline now is widened. There's been public hearings over past few months with all the sectors involved, and now we are carrying out this international seminar, which starts today in order to discuss, by and large, the foundations and challenges of the regulation of artificial intelligence and its several meanings, as, for example, the best international practices, the regulatory of the uh, accountability system. I would like to thank the interest and motivation from all panelists, having in mind that we'll have two fruitful working days for our learnings and the evolution of the debates on the regulation of artificial intelligence. Now, before we start the first panel, I would like to call the rapporteur of our commission, Professor Laura Schertel Mendes. Thank you very much, Mr. Minister Cueva. I would like to echo with you our thanks to the President of the Federal Senate and Senator Eduardo Gomes for the whole support he had given to our commission. Also, the support they've given in carrying out the seminar. And I would like also to thank your leadership, to cheer your leadership in the forefront of this commission, to all the members of this illustrious commission and the secretariat of the commission with whom this event wouldn't be possible. And my special thanks to all our international guests who very kindly and generously made themselves available to take part of these events here today and tomorrow to share their knowledge and experience in that important topic, important for Brazil in the very moment that Brazil is moving on and elaborating its own regulation proposal for artificial intelligence. These international contributions will be very important because this topic sure should not take for granted all these universal aspects, this international aspect. So I think this seminar will serve as a huge, great learning for us all. And I would like to highlight also that despite the international character, the universal and worldwide character, there are local particular features, especially related to the complex Brazilian society, which must also be taken into consideration. And that has been brought, as you put forth already, as Senator Eduardo Gomes has mentioned already, it has been brought in the public hearings, in the over 20 hours of public hearings that we had, showing how several risks related to artificial intelligence can be increased, can be enhanced due to our inequality and structural racism of the Brazilian society. So these aspects that our commission must bear in mind as well. I think that now, as you've mentioned, after the seminar and after the contributions that we received now for a while, given this prorogation, so we can systematize all this knowledge, systematize the contributions, and this will be paramount, so we can deliver uh, a very thorough report, as thorough as possible, to our Federal Senate, to our rapporteur, Eduardo Gomes, as well as to the President of the Senate, Rodrigo Pacheco. And I think for sure, with that in mind, we'll have two great days, and I would like also to wish everyone a great seminar. Now I would like to give the mic to you, Mr. Minister, so we can start our first panel. Thank you very much. Thank you. So without further ado, we'll start our first panel of the international seminar, which starts, and the theme is democracy and the foundations of the regulation of artificial intelligence. We have two moderators for this panel, Professor Laura Schertel Mendes and Professor Danilo Doneda, to which now I would like to give the floor to start our work. Thank you very much, Mr. Minister. This panel entitled Democracy and Fundamental Rights, the Foundations of the Regulation of Artificial Intelligence, will have the illustrious presence of Professor Wolfgang Hoffmann-Riem from Bucerius Law School, Professor Mirel Hildebrand from University of Brussels, Maria Paz Canales from Direitos Digitais, and Professor Stuart Russell from Berkeley University, who will, by the end of our panel, so we would like to thank the presence of everyone, our illustrious international guests, our panelists who accepted to be here with us. And now I would like to call Professor Hoffman Rien, and I would like to introduce him. He's a professor of innovation and rights at Bucerius Law School, Hamburgo, emerit professor of public law and public administration at the University of Hamburg. He had been the head of the Justice Department of the state of Hamburg from 1995 and 1997, and judge of the German Constitutional Court from 1999 until 2008. Professor Hoffmann Rien is certainly one of the greatest experts, one of the most renowned persons in Germany and Europe overall, who talks about technology, data, and artificial intelligence. Professor Hoffmann Rien, now you have the floor. Thank you very much for being with us.
Ja, herzlichen Dank für die freundlichen Worte.
Muito obrigado pelas palavras.
Möchte ich mich gerne, ich muss mal eben
I would like,
den
first of
Übersetzer
all,
anschalten. Augenblick.
I just need to switch off.
Where is it?
Where is it?
No, I have difficulties to switch off your translation.
I have some difficulties of switching off interpretation.
Now, ist es gut. Also ich beginne nochmal. Zunächst einmal herzlichen Dank für diese.
So I will start once more. Thank you.
No, that doesn't work. I'm sorry. Jetzt mache ich einen neuen Versuch.
I will try it once
Ich höre
more.
immer noch die Übersetzung und ich fürchte, dass Sie die auch hören.
I can still hear the interpretation.
Kann ich das wegstellen? Sekunde. Ja, ich bin etwas ratlos im Augenblick. Darf ich noch mal den Übersetzer bitten, etwas sagen, damit wir sehen, ob ich ihn hier störend habe oder ob Sie den auch
Could
hören?
I ask the interpreter to talk once more to see if I can still hear him in audio?
Herr
No.
Rahim, für uns ist alles richtig hier. Ich glaube, Sie brauchen nur das hier umstellen.
Ich kann Frau Schertl nicht verstehen.
Ah, okay.
I can understand.
Ist alles richtig für uns jetzt? Wir hören Sie.
Also Maurice, ich höre immer den
Yes,
Übersetzer.
everything correct. I can hear you perfectly and the interpretation as well.
Vielleicht
Da
nur
ist der
die
deutsche
Umstellung
Übersetzer,
für
da
eine
ist der.
andere Sprache. Sehen Sie das?
Wenn du einfach sprichst.
Versuche jetzt einfach meinen Vortrag zu halten und hoffe, dass Sie das hören.
I
Also
will try to do my presentation only. I hope you can
ich
hear
hätte
me
nur gern
well.
die Information, ob Sie auch im Hintergrund die Stimme des Übersetzers hören.
I'd like just to know if you can hear the interpreter. Can you hear him?
Okay.
Sie hören das.
Ja.
Was mache ich?
Dann sprichst du und wartest, bis er fertig ist mit Übersetzen, dann sprichst du wieder den
Nee, das
nächsten
ist nicht
Satz.
gut.
Ja, was
Well.
Dann können wir das nur konsekutiv machen.
You can
Das
talk
tut mir
and
leid.
finish it and then we can move on. So, or we can do it consecutively.
I'm sorry that I don't speak German at the moment. The reason is that I have had Corona for two times, and I'm still suffering on the consequences, with the result that I have difficulty to concentrate and to find the right words. Therefore, I ask for your apologies that I speak in German. Da ich der Erste bin, der hier spricht, möchte ich ein paar grundlegende Einführungen machen.
Professor, é
Keine
possível
Details
falar em
eingehen.
alemão? Porque nós estamos ouvindo o tradutor aqui. Se o senhor preferir, fique à vontade.
Das
Professor,
habe ich
it's
nicht verstanden.
Sie dürfen auf Deutsch sprechen, wenn Sie wollen.
Jetzt habe ich gar nichts verstanden.
Wir können alles hören auf Portugiesisch hier.
we can all hear you in Portuguese here. You can speak in German, no problem.
Okay, also dann fange ich an. Wir haben es jetzt ja mit einer
Okay,
neuen
so I will start.
Entwicklungsphase in der digitalen Transformation zu tun. Wir hatten uns daran gewöhnt, in den 90er Jahren, die Digitalisierung gibt es schon viel länger, das Aufkommen des Internet
The
als
digitalization exists for the digitization exists for a long time now, since the beginning of the internet.
Prägung der Emanzipation und der Selbstregulierung zu
And
verstehen.
since the
Wenige Jahre
emancipation, so
später
we can understand
wurde
it
durch die
better. And a few
Kommerzialisierung
years
des
later,
Internet diese
by
Zeit
the
zurückgeschraubt.
commercialization of
Und
internet,
die
that
großen
time has returned.
IT-Intermediäre, andere wie etwa Facebook, Apple, Google, Microsoft und sonstige große Unternehmen
And such
übernahmen
devices,
gewissermaßen
such
die Regulierung
huge companies
des
as Google and
Internet.
Facebook had taken
Eine
these
deutsche
regulation
Wissenschaftlerin, Frau
measures.
Schweitzer, hat davon gesprochen, dass die Regeln, die das Internet
A
und
German
die
scientist
Kommunikation digitaler Art prägen,
has
private Gesetzgebung seien, also
has mentioned
keine
about
durch
rules
staatliche
about on
Instanzen
digitization.
geprägt. Und das ist in der Tat richtig gewesen, denn der Großteil der Regelungen war nicht
It
staatlich
is in
und
the scope of the
demokratisch
state
legitimiert.
because many of these regulations
Inzwischen
haven't
gibt es
been taken
Diskussionen
in the
darüber, ob
scope of the
diese
state.
Situation noch weiter tragfähig
So,
ist. Und ich erinnere
thinking
an
about
einen
the
kürzeren
situation, whether
Beitrag
it's feasible for the
von
future or
Gianni
not.
Floridi, der sich
Now,
früher so
I
intensiv
will
um Selbstregulierung gekümmert hat und
give Florid's
mitgewirkt hat,
contribution, who
der jetzt in
mentioned
einem
about the
Artikel dargelegt
self-regulation,
hat, die Zeit der Selbstregulierung ist vorbei, die Zeit der
and which
Regulierung ist
now
verboten.
is saying
Ich
that
würde stattdessen
this
sagen,
time is over.
verboten ist eine Zeit der regulierten Selbstregulierung, also eine gemeinschaftliche Regulierung einerseits
Now
durch
it's the time of
private Unternehmen, natürlich
self-regulation,
auch durch
which is
staatliche
taking
Instanzen.
place
Dass
in
die
private companies as well as
privatwirtschaftlichen
states
Unternehmen einen großen Einfluss auf
themselves.
die Entwicklung der Digitalisierung genommen haben, ist allseits
These
bekannt.
companies have a huge influence in the
Ich darf
digitization,
insofern daran
of
erinnern, dass
course,
das deutsche Bundesverfassungsgericht dies zum
and I
Anlass
would
genommen
like to
hat,
remind
jüngst
you
darüber nachzudenken,
that
ob nicht die
the
Grundrechte, die
The
traditionellen Rechte
the
des
German
Einzelnen gegen
Constitutional
den
Court
Staat
has
sind,
thought
die
about
nicht
the
auch
fundamental
verbindlich sein
rights,
können für diese großen Akteure, die in ihrer
whether
Handlungsmacht
couldn't
denen
they be
staatlicher
connected to these
Instanzen
big
ähneln.
actors that
In
in
diesem
the half of their
Weg folgt, wie
power,
gesagt, das Bundesverfassungsgericht bewegt sich in diese Richtung, dann bedeutet das
and
eine neue
so
Perspektive,
the German Constitutional
Notwendigkeit
Court
des
is proceeding
Freiheitsschutzes
towards this
auch
direction,
gegenüber
and that
privaten
shows
Unternehmen, privaten
that
Akteuren,
the
privaten
protection
Machtträgern.
of
Und
freedom
das ist wichtig,
is also
nicht
very
nur zum Schutz
important
von Grund- und
in the protection
Freiheitsrechten,
of the
sondern auch zur
individuals.
Aufrechterhaltung der Funktionsfähigkeit demokratischer Institutionen.
And so this is
Seit
something very
des
necessary for a
Beginns
democratic
des Internet
institution.
und der digitalen
From the beginning of the
Interaktion
internet
stand im Vordergrund
and
unserer
the digital
Bemühungen der Schutz
interactions,
individueller privater Daten, der Schutz informationeller Selbstbestimmung.
the most important is the protection of
Werden alle
data
Lebensbereiche durch die Digitalisierung durchdrungen
and
und die
all the
Notwendigkeit,
areas, all
dass
life
wir
areas
unseren
is
Blick
being influenced
weiten
by the
und nicht nur an
digitization.
den Schutz von individuellen Daten denken, sondern Schutz an die,
And
an die
we cannot
Funktionsfähigkeit
conceive
aller
about it
gesellschaftlichen
in individual
Bereiche
rights
und
only,
einer
but in the protection
individuellen
of the role
Entfaltung in ihnen.
of
Wir haben
all
es
the
nicht nur mit einer
areas of society and
technischen
the
Innovation und
individuals
damit
as
einer
well.
technischen Transformation zu tun bei der Digitalisierung,
It's not
sondern
only
auch
about
einer
technical
sozialen
innovation,
Transformation. Es werden viele Bereiche, so die der Bildung,
but
des
several
Arbeitslebens
areas such
und
as education
stark beeinflusst, und es ist notwendig, dass man in allen
and
Bereichen
others
auch
are
einen Schutz
strongly
der
influenced, and
Grundrechte
it
und
is
der
necessary that in
demokratischen
all the
Institutionen
areas
bietet. Betroffen sind beispielsweise alle Grundrechte wie
that
etwa die
such
Eigentumsfreiheit,
influence that
die
of democracy
Berufsfreiheit,
should be present,
die
all the
Meinungsfreiheit
fundamental
selbstverständlich,
rights.
die Versammlungsfreiheit und so weiter. Und derartige Freiheitsrechte sind in den Verfassungen, auch internationalen
These
Abkommen,
freedom
nicht
rights
nur als
are
Ermächtigung der
present in the
Freiheitsausübung gedacht, sondern
constitutions.
enthalten auch Schranken der Freiheitsausübung, und zwar mit dem Ziel, dass
They
es eine
are not
Balance
only
zwischen den
to render
verschiedenen
freedom, but
offenen
also
Interessen
to
gibt,
render into
einen
limits
Ausgleich, den man in
with
Deutschland
the
mit dem
goal
Begriff der Herstellung praktischer Konkordanz, der praktischen
of
Abstimmung
creating
unterschiedlicher Rechtsgüter
an
verwendet.
equality
Wie gesagt, es
in the
geht
country.
um den Schutz
As
von
I said,
Funktionsfähigkeiten und Freiheitssicherung in der gesamten Rechtsordnung.
when we
Dabei
talk
ist die
about
künstliche Intelligenz
freedom
als jetzt letzte Stufe,
the
sicherlich
safety
auf
of
Dauer nicht
freedom
die letzte Stufe
of
der
artificial
Entwicklung,
intelligence,
dadurch geprägt, dass die
it
algorithmischen
is not
Systeme selbst
the last
lernfähig sind.
step of this
Mit der
innovation,
Folge,
but we've
dass sie
seen
sich
that
selbst
algorithms
programmieren können,
worldwide
auch mit der weiteren Folge, dass möglicherweise Dritte gar nicht mehr nachvollziehen und kontrollieren können, in welche Richtung
are
dieses
able
Selbstlernen sich
to
entwickelt hat.
be
Es geht also nicht nur um das
as
traditionell schon länger
advanced
bekannte
that we
Machine
have
Learning,
new
sondern es
situations
geht auch um
incoming.
sogenanntes Deep Learning.
We have not
Damit
only
müssen wir fertig werden mit der Situation,
machine learning, but
dass
also deep learning.
die
And in
Kenntnis
order to
dessen,
deal with
was
that
Algorithmen
situation,
leisten, begrenzt ist und dass
the
Dritte nur
knowledge
Zugang zu
is
den
limited,
Steuerungen dieser Algorithmen haben, mit Folgen für nicht nur für die
and
Kontrollierbarkeit,
our
sondern
access
mit
to
Folgen
algorithms
zum
is
Schutz
also
der eigenen
limited.
Interessen und auch der Revidierbarkeit möglicher Ergebnisse. Natürlich ist mit der
And the
künstlichen
outcomes
Intelligenz
we
eine
can
Fülle
expect.
von Chancen verbunden, Chancen der Verbesserung und schnelleren Erledigung von Aufgaben, Einsparung von Ressourcen in Zeit,
And
Geld, Personal und so weiter. Und ich
because
finde es
of
natürlich
the
wichtig, dass diese
economy
Chancen
of
auch genutzt
resources,
werden. Es darf also keine Regulierung geben,
I think
die
that these
Chancen
chances
verbindet,
should be
es sei
used. There
denn,
should not
diese ist
be a
gerechtfertigt
regulation
durch
to limit these
Risiken,
chances.
die verbunden sind mit der Entwicklung. Und ich
But
glaube, dass es richtig
the
ist, dass
risks
ein
are
Gesetzgeber
all together
neben dem
connected to
Chancenaspekt
development. I
den
think that it
Risikoaspekt
is
sehr
correct
stark beachtet und in den Vordergrund rückt. Die
that we
Bill
must be
21,
all
die
eyes
jetzt
on
Grundlage
risks,
unserer Überlegungen ist, enthält eine Fülle sehr lobenswerter
and
Zielvorgaben zum Schutz der Bürger, aber natürlich
we are
auch zum
having
Schutz der
a project
Institutionen.
for the protection
Allerdings habe ich den Eindruck, dass
of
die
the
Aufzählung
citizens
all der
as well
positiven
as for
Effekte,
the
wie gesagt,
Constitution's
die
protection.
ich begrüße, doch ein wenig
So I would
gebiased
like
sein, ein
to
Vorurteil hat, in Richtung auf verstärkten Schutz eher der Anwender und der Entwickler der Technologien als der Nutzer. Und deswegen ist es wichtig, dass wir
an enhancement
hingehen,
for
auch ein hinreichender
the
Schutz vor Risiken gewährleistet
developers of
ist.
technology as
Das
well as for the
erfolgt
users
nicht
to talk
allein
about that
dadurch,
and also
dass
to
Ziele
render
aufgeführt werden,
the
wünschenswerte
protection against
Ideale,
those type of
sondern es
risks.
muss Möglichkeiten geben, diese Ziele durchzusetzen,
There must be a
gegebenenfalls
possibility
ihre
to reach
Umsetzung zu
the
kontrollieren
goals
und falls Verletzungen der Vorgaben erfolgen, dies zu
in
sanktionieren.
order to
Insofern
control
lese ich den
the
Gesetzentwurf
consequences.
etwas kritisch dahingehend, dass er beispielsweise sagt, eine Intervention darf nur
This law
zur Bereinigung und Verhinderung
says that the
realer
intervention
Risiken erfolgen. Was sind
can
reale
only
Risiken?
take
Gerade
place
angesichts der Unvorhersehbarkeit
with
des
the
Einsatzes künstlicher
real
Intelligenz
risks. And what
ist
are
die
they?
Frage der
Things that are
Wirklichkeit
unpredictable
der Verwirklichung von Risiken schwer zu sagen. Es muss auch darum gehen,
that
mögliche Risiken
happen
abzuwehren. Und
also
es muss, wenn gesagt wird,
by
es
the
muss sich
risks
um
that
wahrscheinliche
may
Risiken
come.
handeln, darum auch gehen, dass diese Wahrscheinlichkeit
It
nicht
is
mit zu
also
hohen
important
Anforderungen
reminding that
versehen wird.
possibility of
Angesichts
the
der Offenheit der
challenges
Entwicklung
that are
müssen
ahead of us is very high.
Anforderungen, wie gesagt,
Therefore,
auf diese
we
abgestimmt
need
sein. Und das ist insbesondere nötig,
to
weil die
organize ourselves
Schwierigkeiten
in order
der
to work in
Transparenz
harmony,
und Kontrollierbarkeit auch durch
transparency,
Technologie bedingt und verstärkt sind. Beiträge dazu leistet die
to do a
Vernetzung,
front,
ebenso
creating those
die
networks
verschiedenen
in such a
Zeitdimensionen, die
way
betroffen sind und vor allem die Vielfalt
that we
möglicher
are able to
Ursachen und
reach
Multikausalität
all
von möglichen
dimensions regarding the subject
Außenverwirklichungen, eben
in
auch
order
Risiken.
not to
Soweit es um die Risiken
run
geht,
unnecessary
ist
risks.
deswegen nach meiner Einschätzung nicht hinreichend,
I
eine
believe
große
that
Verschuldenshaftung vorzusehen, sondern es ist
it
notwendig,
doesn't
auch
suffice creating
Möglichkeiten
a
einer
second.
verschuldensunabhängigen Haftung zu schaffen. In Deutschland spricht man insofern
It
von
is also
Gefährdungshaftung.
important to
Natürlich
think
müssen diese
of
Voraussetzungen einer
safety
Gefährdungshaftung näher
fund
umschrieben werden.
that
Dazu
does not
gehören in deutscher
split
Terminologie
the state. It is important to
Verkehrssicherungspflichten,
think
also Pflichten zur Sicherheit
that
der Vorgehensweisen
we must
für
have
diejenigen, die künstliche Intelligenz entwickeln,
guaranteed
umsetzen in
safety,
weitere Software,
guaranteed by the state.
auch
And
die
we
Betreiber
should
von
develop this legal
Infrastrukturen und
safety
selbstverständlich auch die
legal
Nutzer.
security for our
Vor
citizens,
diesem Hintergrund
from the business
verstehe ich
people
die
who
Forderung, die
manage
vorhin von Luciano Floridi. Hier muss auch an Regulierung gedacht
AI
werden.
businesses, because
Dabei
here
wählt
we must
das
bring
der
previous
brasilianische
experiences that have been
Gesetzentwurf
done
durchaus
in
einen
this area
risikobasierten Ansatz, aber sehr viel
of
schwächer, als er
legislation.
beispielsweise in
The
Europa
work
verfügt.
here in Brazil,
Die Europäische Union hat
even
das
if
Problem
we orient
erkannt
ourselves to
und in einem vorhin schon
towards the
erwähnten
Europeans,
umfassenden Entwurf
we must
zur
pay attention and be
Regulierung der
careful
künstlichen
in order
Intelligenz
to
versucht,
create laws
Rahmenvorgaben zu schaffen. Dies handelt sich im Augenblick
that
um einen Entwurf,
cover
aber dieser Entwurf
the
wird
problems these
intensiv
problems to
beraten
come.
und ich gehe davon aus, dass er, wenn auch mit
It
leichten
is
Veränderungen,
necessary
auch in
having
Kraft
support
treten
from
wird.
consultants,
Das Besondere
and
dieses
we will be at
risikoorientierten
your
Ansatzes
disposal.
besteht darin,
Now,
dass verschiedene
thinking about the
Risikostufen
risks,
gesehen werden. Das war übrigens
we
schon in
must
einem Bericht
talk about the
der
level of
besagten
risk that takes
Ethikkommission
place,
Deutschlands so vorgesehen,
thinking
also eine
on
risikoorientierte
data
Regulierung,
security,
verschiedene Stufen
that
der
a
Risiken
legislation
identifiziert und
which
darauf bestimmte
is oriented
vorsieht.
not
Der
only
Entwurf der
risk-based,
Europäischen
but must
Union
be also oriented
sieht
towards
vor, dass es zum einen
towards
Praktiken
data
gibt,
protection.
die
The European
grundsätzlich
Union,
verboten sind,
in the
die
European
also
Union,
überhaupt nicht
there are a
geübt
few
werden
practical
dürfen.
steps that have been
Dazu
taken
gehören
already,
etwa Versuche der
but there's a lot to be
unterschwelligen
done yet.
Beeinflussung der Bürger oder
We have here
der Ausnutzung der
transitions
Schutzbedürftigkeit
to
einzelner
spaces where
Bevölkerungskreise und
we need to
dergleichen.
protect the citizens,
Neben dieser ersten Kategorie der verbotenen
and we
Risiken,
cannot
der verbotenen
forget
Verwirklichung von Risiken, stehen sogenannte
that among the
Hochrisikosysteme.
risks,
Ich darf Ihnen dazu mal
we
kurz
have high-risk
vorlesen, was
topics,
in dem Entwurf
and
dazu
I
im Grunde
will
heißt. Es geht beispielsweise um Verbote
Read
der
some of them.
biometrischen Identifizierung
instance,
und Kategorisierung natürlicher Personen, die Verwaltung und den Betrieb
prohibiting
kritischer Infrastrukturen im
the
Bereich der Verwaltung,
biometric surveillance of
der
citizens,
Stromversorgung, aber auch
the
den Einsatz
biometric
bestimmter
recognition of
Systeme künstlicher
citizens,
Intelligenz im Bereich der
and
beruflichen
so
und
that
schulischen
artificial
Bildung,
intelligence
der
systems
Einstellung und Auswahl natürlicher Personen sowie
cannot
bei Entscheidungen über Beförderungen und Kündigungen von Arbeitsverhältnissen.
surpass
Solche
the
Handlungen
right
sind
of
nicht
privacy
verboten,
from our
sie werden
citizens.
aber einem System der
This must be
Kontrolle
prohibited,
unterworfen
and
und
there
damit
must be a
der
control
Möglichkeit versehen,
upon artificial
dass
intelligence systems.
hier der Staat nicht nur kontrolliert, sondern eventuell auch regulativ
The
interveniert.
state should
Dann gibt
work
es eine
not only
große
in
Gruppe der
the control, but
Risiken
also in
oder
cooperation
auch
with
gefordert
artificial
wird,
intelligence
dass die von
systems.
den Unternehmen selbst oder ihren Verbänden so behandelt werden, dass auch minimale Risiken, wie sie etwa durch Videospiele oder STEM-Filter verursacht
Companies
werden können,
cannot
sich
be
wirklich verwirklichen.
in full
Das
autonomy.
Hauptproblem besteht natürlich
The
darin,
state control must be
wie man
present,
auf diesen
as well as the
verschiedenen
state
Risikostufen
cooperation.
angepasste Regelungen zur
Now talking about
Risikoabwägung
risk
vorsieht.
levels.
Das kann ich jetzt nicht im Einzelnen ausführen. Das ist in dem Entwurf der Verordnung.
I
dort
cannot
stehen.
list
Ich
each
möchte
and every one
generell
of them
auf
here.
Möglichkeiten
I
des
would like,
Eingehens auf Risiken
by
und der
and
Verhinderung
large,
von Risiken eingehen. Dazu gehört zum
to talk
Beispiel die
about
Einrichtung von Pflichten
the risk
und zwar zur
issues.
Abschätzung von Folgen, bevor die Systeme genutzt werden,
Note,
aber auch während
realizing before
also Pro-
this
und
thing
retrospektiv.
is mentioned,
Es geht
we must
auch
be
um
prepared
Pflichten,
so that after
dass
it
die
happens,
Unternehmen
we are able to
leistungsfähige
react.
Managementsysteme in ihrem Bereich einrichten, die in der
When we
Lage
talk
sind,
about
Vorgaben der Regulierungen einzulösen. Dabei sind besonders
the
wichtig Sicherungen
regulation,
der
we
Transparenz,
must
Sicherungen
try to
der
foresee the
Verantwortlichkeit,
risk issues.
natürlich auch
We
der
need to work with
Kontrollierbarkeit des
transparency,
Einsatzes der neuen Technologien
accountability,
und
in order
letztlich
to generate systems of
Regulierbarkeit.
control upon these new
Wenn man das sichern
technologies.
will, reicht es nicht, Appelle zu äußern oder
If such
Institutionen
isn't possible,
aufzufordern, sich darum zu kümmern,
we
sondern man braucht
must gather the
weitere
state,
Instrumente,
legislators,
so
and
beispielsweise
institutions
des
to
Monitoring
work
Einsatz dieser
all
Technologien,
together,
der
monitoring these
Protokollierung der
technologies.
Vorgehensweisen und dies auch möglichst der eben
We
lernenden
must
Systeme
protocol the
und
procedures
der
as
Dokumentation
well
sowohl der
as
Vorgehensweisen als auch der Folgen.
learning machines.
Dies kann selbstverständlich auch durch Selbstregulierung geschehen, also etwa durch Codes of
I can,
Conduct.
of course, by means of the self-regulation.
Die Erfahrungen in der Vergangenheit muss man allerdings feststellen, dass die Codes
We
of
have
Conduct
the previous
sich im Bereich
experience,
der
which
Internettechnologie
shows that the
entwickelt
codes
haben, in vieler Hinsicht
and what
einheitlicher
we've
sind,
experienced
als sie die
on the
Interessen der
internet,
betroffenen Unternehmen
on the
deutlich
several
über die
fronts,
Interessen der Nutzer
we
stellen.
might lose
Dies kann man nur
control and the autonomy
verhindern,
can be
indem
taken.
man
And that's
ein
something
System, so nannte ich es vorhin, der regulierten Selbstregulierung
that
einrichtet.
if we
Das
lose
heißt, dass
control, we cannot
auch
control
für
later on.
Verhaltensregeln wie Codes
The
of Conduct
self-regulation cannot be
bestimmte
present
regulative
even
Vorkehrungen
in
geschaffen
creating
werden,
codes,
um Risiken
processes,
zu vermindern.
processes and
Und,
learning
diese
processes so
Codes
that
of
we are
Conduct
sure
dürfen, so
to
jedenfalls, wenn
minimize
sie besonders
possible
wichtig
risks
sind,
by means
einer
of artificial
Kontrolle,
intelligence.
etwa durch Zertifizierung bei einer unabhängigen Stelle, die
We
versucht
need to have
zu klären,
certifications or independent instructions that can.
I'm sorry, I didn't understand. Who intervened? I'm going to finish very soon. Okay.
Alles gut.
Yes, I just said important are certification systems and their independent control. It's also important that it's possible to ask the courts to intervene in cases of violations and to have an independent agency by the government to oversee the conduct of this part of the industry. Okay, these are only some remarks. I could continue for hours, of course, because it's a big subject, but I'm sure we will hear lots of new ideas and good ideas during the next time. I thank you for your patience to listen. Thank you.
Muito obrigado, Dr. Wolfgang Hoffmann, pela excelente, brilhante.
Thank you so much, Dr. Wolfman Hoffmann, for your wonderful and brilliant presentation. We are going to introduce now Dr. Mirelle Hildebrand from the University of Brussels. She is a professor in the university as a doctorate in criminology. She's also in the University of Holland, and her work concentrates in philosophy, right, and identifying the impacts of artificial intelligence. In 2018, Mihaly got an advanced research sponsorship to counting with the human being in the computational right. We thank you so much, Professor Mirelle, for accepting our invitation. Please, yours is the floor.
Thank you very much, Professor Doneda, and thank you also for inviting me. I'm going to immediately share my screen because I see that the host has disabled participant screen sharing. Maybe the host can enable this. Then I can share my screen. This is a small technical hiccup. It's always when we speak about technology, we notice how software controls all of us. So it's okay, I'm co-host. Very good. This shows that the same software can also solve our problems. Okay, I hope you can see the slides. Yes, okay, very good. So let's talk about, let me see if I can shift. It's not moving. I have to stop sharing and try it another way because we are human beings. We are very clever. Let me try it this way. Very good. Now it works. So you see, it's all about human-machine interaction in the end. Let's immediately move to my first slide. So I think that the question whether we need specific legislation with regard to AI is a very important question. And then the next question is, of course, what type of regulation? And I will argue that we need two things, and I'm going to focus on the protection of fundamental rights. But I must say that I'm also very focused on the protection of our health and safety, because I think our first concern should always be the reliability of these systems. And the question whether the claims that are made on behalf of them by entities that have an interest in us believing those claims, that those claims should be substantiated for these systems to be reliable. So I believe these are technologies that are fundamentally different for a number of reasons. So this is about automation, and automation means that you can do wonderful things and you can automate them so you can scale them. The problem is, of course, that that means you will also automate things like error, bias, and hazards for safety and health. It is also very important to see that these systems can redistribute power due to the speed, the remote control, and the networks effects that are inherent in these systems. And whoever controls them, has access to them, has an interest of their own, of the way they work, means that the checks and balances between different powers in our societies are shifting. And we see that, of course, with the rise of big tech companies with enormous economic power. But that economic power is directly related to, for instance, the network effect of the technologies that they control. Now, there's another concern some of these technologies, especially technologies capable of what we call learning, basically manage to anticipate and preempt us. Now, it may be that they're not really anticipating us and not correctly anticipating us, but it's very difficult to find out because these systems respond to what they infer we are going to do. And that means their actions are going to have effects on us. And here again, we must look at risks to fundamental rights and freedoms of natural persons that are due to the visibility they create of us as persons, especially with regard to our future behaviors, and the fact that this visibility is invisible to us largely. And this undoes a number of checks and balances of the rule of law. It's again about redistribution of power balances that we took a couple of centuries to install, and that are now shifting. And that makes it very important to offer legal protection. And it's also very important to note that this legal protection is not just about individuals, but it's also about the protection of these power balances within society. So it's also the protection of institutional arrangements, certain independence, for instance, of the court, that are key to the way democracies function, must be protected by the law. As we all know, things like economic markets are created by the law, by private law, but also by public law. Now, I believe that for us to be safe and to be able to enjoy fundamental rights and freedoms, it is key that those who provide these systems, that means put them in the market, and those who deploy them should conduct fundamental rights impact assessments to foresee, to anticipate the consequences of using these systems. And that, as a consequence of that anticipation, they should build checks and balances into the architecture of the systems that they are building. Now, one of the key questions here is, how should AI be defined? It is clear that in the scientific literature, on the side of the scientific domain of AI and computer science, there's a lot of discussion about that, but we are not really concerned with that. We are concerned with legal protection and ordering our society. So from the legal perspective, it is first of all important to decide what type of systems are we talking about. Is it about software? Is it about hardware? Is it about software infrastructure? And I think it is very important that both the OECD and also the European Union in its latest revisions now speak of systems. They don't speak of software. They speak of systems to make sure that this is technology neutral. So we might now want to talk about software and hardware, but we don't know where developments are going. So let's talk in terms of systems. And a second point is, should we restrict AI regulation to systems that learn or not? And in the European context, the example of the Excel sheet has gone around, because part of the definition in the proposed AI Act is systems that are based on logic-based or knowledge-based. And some people said, well, if you define it that way, then an Excel sheet will fall within the scope of the regulation. Now, I think, knowing that Excel sheets are the most used software in this world, we should not think that an Excel sheet by itself comes under the Act. Of course not. Why not? Because there is a condition for something to fall within the scope of AI systems that says that we're talking about systems that interact with their environment, that influence their environment by way of their decisions or their behavior. That's important. So that means an Excel sheet in itself is not an AI system. But if an Excel sheet basically implements a complex or an important decision tree that has a major effect on people, think of a calculation whether somebody is going to obtain an insurance, the premium of that insurance, which may exclude certain people, depending on the variables that are used. We can talk about discrimination. We can also talk about the decisions about social benefits. These can be at some point put into an Excel sheet. And I would say it's very important to make sure that these kind of automated decision systems that may not be learning, but they may be the result of machine learning systems that try to unearth the relevant features that then end up in the Excel sheet. But even if that's not the case, if that Excel sheet has an impact, interacts with its environment, and has a major impact, I think it should be under the Act. So the focus of defining AI should be, on the one hand, on impact, because we're talking about law, not about a scientific discussion about the ontology of artificial intelligence. We're talking about how is it going to impact individuals and society. And there I think a precautionary approach is important. I also think that precautionary approach is called a risk approach currently, but it's basically about not being risk averse, but saying we have to anticipate risk, avoid them if possible, and otherwise mitigate them. And of course, we're talking about a specific type of systems. And I think it is important to broadly define them. And this brings me to the OECD principles regarding AI of 2019 that clearly have an enormous impact on all the regulatory efforts that are made at a global scale. One could say that for a long time, there was competition, geopolitical competition on the development of AI. And at this moment, we see a competition in the regulation of AI. That is going to be very important. So the OECD definition says an AI system. It talks about systems, machine-based system that can, for any given of human-defined objectives, make predictions, recommendations, or decisions. Here, I would say that it is important to see that many of these systems have behaviors. And of course, you can say, well, behavior, that means the system took some sort of decisions to behave. But I would make a difference between two overlapping things, decisions and behavior, because things like robotics, but also connected cars, autonomous cars, if they ever come about, airplanes, medical devices, they behave in a certain way. And we need to protect ourselves against detrimental impact. The key part of the decision is that they influence real or virtual environments, and the OECD definition also recognizes that there are various levels of autonomy. So we're not just trying to regulate artificial general intelligence, if that ever were to come about. We are looking at real world systems as they are now and as they may come about. Interestingly, the OECD goes a bit further than just this dry decision. They look also at the AI system lifecycle. They look at the design, the construction of these systems, but importantly at the verification and validation. Because it is nice to be in favor of innovation, but we want reliable systems. So we need in the legislation to make sure that these systems are verified, validated, that they're safe. And for instance, that they do what they're claimed to do. Then of course comes their deployment. That is different from building them and providing them, their deployment. So that means by a hospital, by a government agency, by a e-commerce shop. And once they're deployed, it's about their operation and monitoring. The OECD then talks about AI knowledge and very adequately clarifies in what they write, that this is about human skills in interacting with this technology, extent to which it is governed, controlled, etc. And finally, they distinguish between AI actors, that are those who are actively involved in the AI life cycle, and the stakeholders, which is a bigger group. That's both those who are involved somehow in this life cycle, but also all those that are affected by these systems. On top of that, the OECD clarifies that in times of climate change and the need for inclusive growth, when designing, developing, providing, and deploying these systems, we must take a proactive approach to these things. We must make sure that they are developed in the context of respect for the rule of law, human rights, and democratic values. And this is not self-evident. We can't take for granted that it's that way because these systems act on their environment. That means on us. So we need appropriate mechanisms and safeguards. The third point is very important. We all talk about transparency and explainability, but they also talk about a general understanding of AI systems in such a way that people are capable of contesting, of challenging the output of these systems. And then, of course, we have to prevent unreasonable safety risk by implementing robustness, security, and what was the third one? Anyway, safety, of course, safety. We want to be safe. Now, another point I want to make is that just writing down in a regulation some wonderful high-level principles is not going to protect us. The devil here, the protection, is going to be in the details that are in the positive law. And I'm just going to walk you through one example, which I think is very interesting. Article 14 of the AI Act, which is about human oversight. This is basically the oversight with which a human being is tasked at the side of the deployer of the system. And this is not a human in the loop, as this famous quote is. From a computer science perspective, it's very important to know when you're building a system at what point a human being should make decisions. Human in the loop makes a lot of sense. But when we're talking about human oversight, about the role played by these systems in human society, we're talking about something else entirely. And we need that human oversight to be effective. That means preventing, and if that's not possible, minimizing the risks to health, safety, and fundamental rights. And now come a set of very far-reaching requirements that are in Article 14. Those who are doing the human oversight should fully understand both the capacity of the system and its limitations. Now, that's a bit over the top, one could say. That's a bit over the top. I nevertheless think that it's very important, because if we do not understand the capacity and limitations of these systems, it doesn't say you have to understand the inner workings of the system. That's another thing. The capacity and limitations. If we do not understand that, there is no human oversight. Then the Act says one should be, those who are in charge of human oversight should be aware of automation bias, so they should resist the urge to say, well, you know, this system was put together by very clever people, very intelligent people. It is being certified, whatever. So it's probably true because perhaps it confirms my own bias. No, we should resist that and be vigilant. We should be able to, or the person doing the oversight should be able to correctly interpret the output and to, at some point, if necessary, overrule the system, make their own decision, that person tasked with human oversight, or even halt the system. Now, it's clear that these are not requirements at a technical level, because this is legal protection by design. This is something that the provider of the system, and that means the developers of the system, must make sure this system affords. So it's not easy, it's a task, but it's crucial, because just try to think of a system where this is not in place. That would mean becoming dependent on systems where we basically have no idea what is happening and have no way of interacting with the system or deciding not to interact with the system such that we're out of the danger zone. Another key question, who is protected by this legislation? Clearly, the idea is to protect natural persons, but of course also corporations and public administration, because these are entities that are going to use to deploy these systems. You're going to depend on them, and it is key that these systems are reliable. And that goes especially when we're talking about democracy for the judiciary and the legislature. The important question, and Professor Hofman-Riem has just spoken about that in detail. It is a key question that in the legislation, the liability of the liability for these systems is well regulated, because if you don't do that, then everything else, all the other requirements you make, come to hang in thin air because nobody has a real interest in taking care of them. So in the EU, those tasks, those made accountable, are mainly the providers, and they're tasked with legal protection by design. They have to build these checks and balances into their system. Those tasks, those made accountable, are not the developers. Of course, the providers are now forced to make sure they get the right developers and that they tell the developers what to do. But it's not the developers that are made accountable. There is a broad research exception now in one of the new versions of the Act. And most of the accountability is also not on those who deploy these systems. And I think that the balance there between the responsibility of the providers and those who deploy the systems is a bit skewed. Now, the issue of liability is about the burden of proof, what constitutes wrongfulness, and about to what extent damage has to be proven, by who. And I think at some point it is very important to introduce strict liability or reversal of the burden of proof, depending on what this technology does. And I'm very much looking forward to the update of the product liability directive in the EU and other relevant directives and regulations to see how the Commission and the European legislator is going to target these different levels of liability. And of course, there's a role of insurance to be liable as a company. If you did your best to produce or to put into the market a product that is not dangerous, then you're probably insured. But if you thought that, well, you know, whatever people do with my stuff, that's not my business, then of course, insurance companies may say, we're not going to take this risk. And here, this is important because we do not want systems on the market that are actually dangerous. So very briefly, Professor Hofman-Riem has already spoken about it. As we know, the AI Act in the European Union, the proposal focuses on high-risk systems. I could say a lot about that, but let's just pick out some of the requirements that are targeted to high-risk systems. And the key thing is that these requirements must be sufficiently detailed. Otherwise, they will not be effective. And I'm just going to walk you through them very quickly because I'm going towards the ends of my talk. So there is a requirement to put in place a risk management system. And that means you have to estimate the risk for safety, health, and fundamental rights infringement with regard to others using your system as you intended. So according to the intended purpose. But very importantly, that risk management system, as it stands, also asks the provider to anticipate risks with regard to reasonably foreseeable other use, which would mean that you cannot say, well, I made it to do this. If you want to use it for something else, that's your problem. I'm not responsible. Because of the nature of these systems, their unpredictability, their network effects, that's not a responsible way of making entities who are providing these things, putting them on the market, liable. So risk management doesn't mean the risk has to be zero, that's impossible, but you have to anticipate it and if possible, avoid the risk and otherwise mitigate it, and you have to document it to show it. There are rules for data governance. This is about the training, validation and test data. It's about the appropriateness, the reliability, the representativeness, the bias, of course, quite detailed again. And that's important because without that detail, you have no real protection. Accuracy, robustness, cybersecurity, record keeping, technical documentation, important post-market monitoring. As a provider, you can't say, okay, I've put it on the market, now I'm done, I'm no longer liable. That's for the deployers. No, the Act says you have to keep on monitoring. Why? Especially when these systems are learning. But I would say also if it is just decision tree, determinative programs, you have to keep monitoring, because if circumstances change, the behavior of the system might nevertheless be unexpected. So there is a requirement for automated logging, and there is a requirement for putting in place a quality management system. And that quality management system only regards your intended, explicitly intended purpose. So the risk approach requires that providers foresee risks when used for the intended purpose, but also when used for reasonably foreseeable other purposes. And we're talking about risks to health and safety and risks to fundamental rights and freedoms. The risk that these rights and freedoms will be infringed or even violated. And basically it requires a precautionary approach, which should not be confused with risk aversion. It's the contrary. It requires you to make an extra effort to further explore the technology, to foresee what sort of damage or other implications this technology has when you put it in the market. So importantly, the Act basically requires that providers instantiate legal protection by design. I'm not talking about legal by design. That would mean that you move from law to some sort of discipline, that you make it impossible not to act lawful. I'm not at all talking about that. I'm talking about implementing checks and balances into the architecture of these systems such that one can exercise one's fundamental rights. So the AI Act, and this is of course maybe this is an old-fashioned image. Maybe we are bored with this image because we have seen it too often, but it's very important. It's about balances. We need checks and balances here, also in the economic sense, of course. But we also need the sword. So it must be effective. It must be enforced. And that was my last slide, and I will stop sharing. Did I stop sharing? Yes, I did, in one stroke.
Thank you so much, Professor Hildebrandt. Muitíssimo obrigada, professora Mirelle Hildebrandt, pela brilhante palestra.
Thank you so much, Professor Mirelle Hildebrandt, for your speech. These were very key elements for all of us in a very complementary way. Your speech was marvelous, and I would like to highlight some points that you gave me, and the importance of regulate with a lot of caution and responsibility, the system of liability and responsibility, and the effectiveness and the importance that this system of supervision has, and the requirement.
Para que esse sistema e para que essa supervisão seja realmente efetiva. Então, foi realmente muito útil e impressionantemente prática. Então, muitíssimo obrigada por essa
It was very practical, so thank you for your contribution. And now I would like to invite Dr. Maria Paz Canales from Direitos Digitales. Thank you, Maria Paz, for accepting our invitation. I will read quickly your curriculum. Maria Paz is lawyer by the University of Chile. She has master's degree in law and technology by University of California, Berkeley. She was part of the team that founded Direitos Digitales, a NGO from Chile who works since 2005 to promote human rights in digital environments in Latin America. Between 2017 and 2021, she's been the executive director of Direitos Digitales, and she's currently the global political advisor. Please, Maria Paz, you have the floor.
Thank you very much for the invitation. I will share also my presentation. If you allowed me to share, I think I need credentials. There we go. So thank you very much for this invitation. It's my pleasure and my honor to be able to speak to you today, sharing a little bit of the experience that we have developed as a human rights organization that works fundamentally in how the technology impacts the exercise of fundamental rights. My personal experience is linked also to how all this technological evolution have posed fundamental changes in the economy and in the way in which the incentives in the market are developed. And this is very aligned with the concerns that we have when we think about artificial intelligence. So the first things that we should consider when we are talking about how artificial intelligence can impact the exercise of fundamental rights and the exercise of the democracy at the end, we should think when these artificial intelligence systems are deployed, for what purpose and for whom, who will be the beneficiaries of these technologies. So in all these decisions that are frequently made by private and public actors are deep social implications and deep economic implications. And this is eminently political in terms of the choices that we have to do in order to implement these systems. It's not the same if we are thinking about artificial intelligence systems that look for purely economic efficiency, for example, when you want to improve procedures and operational outcomes in something, then when you are thinking that the same system or similar system will be put in place to administrate justice and determine who can receive welfare benefits from the state. So in any of the cases, even though if they are very different in the impact they can have in the fundamental exercise of human rights, we are talking always about how this system impacts the human development. And therefore, in all these cases, even though they have different implications and there are different political choices implied in the selection of the system and the implementation of the systems and the regulation provided for those implementations, in all those cases, what we see is that they are touched by the obligation, the current obligation that the state have in terms of human rights at international level. So we can see a little bit more of that idea in a publication that we made as Derechos Digitales a few years ago, and I shared the link here in the screen if you want to look deeper on that. So what is expected from a law that attempts to regulate artificial intelligence if we are considering that we are saying that because of the implication of these technologies, there will be always impact in the exercise of fundamental rights? So what we should look when we are considering the implementation of a law, of a regulation of this matter, we should look for things that go beyond principles and ethic reference, because we have seen already around the world a previous trend with many different international bodies or even private efforts or national efforts to try to identify the common elements in ethics that could deal with the different issues and questions and risks that pose these technologies. And if you allow me, I can share you this figure that it was a part of a report from the Berkman Klein Center of Harvard University, in which in 2020, they collect a number of different instruments that try to provide an overview of the different principles that have been pointed out as the principles that should guide the implementation of artificial intelligence. And we can see that here we are not finding a very clear path in terms of implementation, because what the ethics dictate, it can be very different depending the place in which these different instruments are developed. So we are not finding a useful guide that can be easily and practically implementable in law when we are just looking at ethical principles. The same or something similar was identified by another set of authors that in 2019 also published this paper that I am referencing here, pointing out at the landscape of artificial intelligence ethics guidelines. Although in this case, for example, the authors were able to identify a group or a set of families of principles that were more commonly identified in the different set of guidelines, and that could be helpful in terms of thinking about a more strict or formal form of regulation, direct form of regulation through legislation of the risk and the implication of artificial intelligence. And here we are starting to see some elements that we clearly are able to match with the framework of fundamental rights at the international level through the commitment of human rights that the different states are, as the case of Brazilian, the case of Brazil, in which those rights are recognized. The fundamental rights are in the Constitution, are in the international commitment, either in the UN system or also in the Inter-American system of human rights protection. So coming back to the question of what should be expected to a law that attempts to regulate artificial intelligence, if we already have all this more general framework that had been provided, and we have seen that they fell short in the practicalities for the implementation in terms of provide the guidelines that provide an effective protection of the fundamental rights in the implementation of artificial intelligence, what we need to go is to a law, a proposal that as a matter of process cover all the elements that will make concrete this fundamental rights protection, and not to a law that simply state general principles or are presenting the idea of artificial intelligence with a shape of technological optimism that lay down the risks that are possible to incur with the deployment of these technologies. And for this, I want to take one step back and to refer also that for achieving the purpose of effectively protect fundamental rights in the deployment and use of the, artificial intelligence, it will be not only relevant what is stated in the specific law that you want to design, but also what is the context in which that law will be inserted in order to ensure that the deployment of artificial intelligence has a positive impact. So, jointly with thinking about the legislation, particularly about the implication of artificial intelligence, we should be thinking what are the other regulations and policies that are in place in the country in terms to understand who is in the data that will be feeding those artificial intelligence solutions, what are the unknowns or the data deserts in the application of those artificial intelligence solutions that will be developed in the country, what is the level of internet penetration, what is the availability of devices, what are the digital skills in different population groups. We cannot ensure that the result of the implementation and deployment of artificial intelligence in a country will be ensured only by the element that will be established in a legislation, but also we need to care about what will be the equity and the impact in democracy of the artificial intelligence, looking to this overall context of different policies that should be going in confluence with the regulation that will be proposed. And this requires then that the legislation is built on top of other policies, the policies regarding personal data protection. That is a point that is already advanced by Brazil with the recent legislation, the regulation about open data access, how the legislation of our artificial intelligence will connect with the possibility of having a fair access to data in order to ensure the functioning of this type of system. What are the digital skills for the broader population in order to be able to contest the system or understand the functioning of the system? So this is directly linked to the previous intervention of Professor Hildebrand, in which she was talking about a human oversight and human intervention, human in the loop. That only can be effective and guaranteed if they're effectively developed the skills for understanding the functioning of the artificial intelligence, and that for the ones that are in control of the artificial intelligence, but also for those that are affected by the artificial intelligence. And very salient what happened with the public servants and the knowledge and the capacity of understand this system and challenge this system that need to be deployed in conjunction with the deployment of these technologies, that is not sufficient only to regulate legally what will be the limitations in the use of these technologies or the way in which they should be implemented, if we don't have that base of knowledge in the people that empower the possibility of control and make the human oversight something effective. And the inclusive growth, sustainable development, and the improvement in the quality and efficiency of the services offered to the population will be the result of all this together, not only the result of the principles or the rules that are deployed in the artificial intelligence regulation. So in order to enter directly to the particular recommendations that I want to share today in terms of what should be covered by the artificial intelligence regulation, I think that is very relevant to take a look to this quote from the resolution and the right to privacy in the digital age from the Human Rights Council, in which it's calling directly for minimize the risk of impacts of adverse impact of these technologies in the exercise of fundamental rights, particularly the right to privacy, but other fundamental rights. And talking about this in the full cycle of life of the technology, since their conception, design, development, and deployment. And for this, it's necessary, as I was referring before, ensuring the safety and the high quality of the infrastructure, and to put in place the due diligence process that are necessary in previous form in order to mitigate the adverse human rights impact. And again, here, this is linked with the experience from Europe that Professor Hildebrand was pointed out in her intervention, in terms that this is a necessary exercise of foreseeing what will be the eventual negative impact that can have a technology, not only what it's constated in the moment, but also what could be a possible risk in the future when the technology is offered and continue this round of learning and advancing by itself. So considering this framework that I have shared so far and the experience that we had as Derechos Digitales, analyzing some deployment of artificial intelligence initiatives in Latin America in the recent years, we would like to highlight these different elements as the different topics that should be covered by an effective artificial intelligence regulation. The first thing that I think all the intervenants during this day in this conversation have already highlighted the need of human rights impact assessment that can be conducted from the very beginning of the idea of putting in place or designing even these technologies, and consider them not only something that exercised in a specific moment, but something that is ongoing, that it should be reviewed and constantly improved in terms of the data that is flowing during the implementation and during the cycle of life of a specific technology. Another thing that I think that was already highlighted, but I will reinforce, is the need that this deployment of system can be demanded, and the legislation in some way demand from the deployers, either private or public entities, that those deployment of systems and design of system can be participatory in their design and in this ongoing assessment that I had referred previously, because otherwise it will be very difficult to understand and identifying the unknowns that I was referring at the beginning as part of the context in which the artificial intelligence need to insert it, and also because this is fundamental in terms to address the issue of bias that is fundamentally linked with my next point, which is equity. Equity, and I choose equity and not non-discrimination or bias or inclusion, because equity, it's a concept that in some way capture all the other trees in terms of requiring that the development of the artificial intelligence system consider the different stakeholders, not only the direct user or the designers or the developers of the artificial intelligence, but those that will be finally impacted by the deployment of the system. And this not only in a way in which there are one point of intervention, maybe to a public consultation, and then in no other moment they are consulted or implicated in the process, but rather to think about equity as something that is an ongoing process that should be provided during the whole life cycle of the artificial intelligence. And equity also have the second facet that it should be regarded, that is regarded to who benefits from the development of the artificial intelligence. Equity also need to provide for the economic and social equity that means that those artificial intelligence systems that will be improving efficacy and efficiency in society and creating economic value, the benefit of this also should be shared in a equitable way with those that are being providing the data and the elements for the creation of this system and for the creation of this value and these improvements. Then we have transparency. It's essential in terms of being able to oversight the artificial intelligence, and transparency should be covered in terms of what are the economic deals, for example, that are behind the development of the artificial intelligence system, but also transparency about the system itself in terms of the element that can be provided for ensure the next element that I have in my list, that it's explainability in the functioning, and this explainability and this transparency will be again fundamental for ensuring that is possible in an effective way exercise the controls that can be established by the law, particularly the human intervention and the human oversight that we were talking before. Then we have safety that we have talking extensively, or Professor Hildebrand also referred as a fundamental issue. This is for me, it's not a separate issue from the fundamental rights. The safety is essential for also ensuring that there are not negative impact in fundamental rights. The right of health is also a fundamental right. So we should think about the safety of the system as a specific requirement that should be considered in the elements of the law. Then we have liability, redress, and independent oversight that are three fundamental pieces of the accountability that have to be established by the law. About liability, I will not extend too much. I only want to react in terms of the possibility of specifically determine who is responsible for the negative impacts of the deployment of the artificial intelligence. I think that the model from Europe that Professor Hildebrand presented is very interesting in terms of setting the responsibility, the liability in the economic agent that has the favor in terms of the control of risk, the better position in terms of control of risks, and also the agent that have the economic benefit of the deployment of the artificial intelligence. And also the idea of having maybe as a complementary way, another statute that cover the negative impact that can be diffused with other type of insurance system or universal fund that cover. I think that this is those are mechanisms that are worth to explore for the cases in which will be very difficult to determine how to assign that liability, or that liability is spread in a very diffuse way in which the redress, the reparation that can be implemented will be very difficult to assign. So finally, I will talk about the independent oversight. I think that it's essential that the law for be really something that will be provided of the necessary efficiency, efficacy, will have to consider an independent oversight mechanism, and that will be the only way in which the transparency and the democracy principles will be sustained in terms of the possibility of limit what will be the impact of the deployment of the artificial intelligence systems. These elements are also identifiable in the recommendations on the ethics of artificial intelligence that the UNESCO issued last year, that it was adopted with the concurrence of the different state members, among them Brazil. And particularly in this code, I want to highlight the need of the impact assessment on artificial intelligence system. That is something that all the different instruments that I am quoting agree. And also about the remediation mechanisms that should be put in place, that the law should be very specific in terms of demanding inside the liability that those remediation mechanisms cover both impacts that are created by the deployment by private actors, but also by public actors. Finally, I want to also join the Professor Hildebrand in terms of the call for consider that the artificial intelligence deployment should be precautionary. In that sense, I respectfully warn you about the consideration of making a declaration inside the legislation about the guarantee of a progressive adoption of artificial intelligence, as currently is drafted in one of the bills that we are examining. Because the goal of deployment of artificial intelligence, it should be a goal by itself. It should be the goal of artificial intelligence as any other technology that should be only fostered where is evidence of the benefits for human development. That is the deepest meaning of the idea of a human-centered technology and artificial intelligence that is human-centered, because the idea of that in all cases that the deployment of this technology would have positive outcomes is tainted with an technological optimism that not always match to the reality. And is for that also that is problematic that in some declaration is stated that the human oversight will be implemented only when it's necessary. we should consider that because technology and artificial intelligence should be in all the cases human centered, it will be always necessary and human oversight. And for understand where that human oversight is necessary, the key are the human rights impact assessment and the clear prohibitory prohibitions in the regulation when there are evidence that there are specific artificial intelligence systems that can be definitely harmful for the exercise of fundamental rights and democracy. So all this also was pointed out in the right to privacy in the digital age resolution from the human and in the report of the United Nations High Commissioner for Human Rights regarding the right to privacy in the digital age, in which the commissioner made a specific call for implementing regulation to safeguard and protect human rights, and also consider to ban a specific artificial intelligence application when it's not possible to compatibilize their deployment with the respect of fundamental rights. And in all cases, her call was to adopt legislatory and regulatory framework that adequately prevent the risk of this type of technology. So my final thoughts for closing this intervention, my 4 ideas that I want you to take on for the task that you have of drafting this legislation, that decision-making processes about artificial intelligence, adoption and deployment, they should be much more transparent of what they currently are in society. We don't have currently a specific regulation, but the artificial intelligence solutions are being deployed day by day. And those decisions are not being transparent to the citizenship. And the law should ensure that all those decisions, either from private actors or public actors, should be much more transparent and not a matter of opaque administrative decision. The choice involved in artificial intelligence cannot be taken in isolation. There are a number of policies that I mentioned in my intervention that provide the contextual condition to have an equitable impact of these technologies in the population. There are implementation of artificial intelligence that pose severe risks by themselves. So this risk approach that it was implemented in the European legislation precisely pointed out to that. There are specific technologies that can be incompatible with the exercise of fundamental rights. If for identifying which are those, we need that the regulation consider human rights impact assessment and clear prohibition in the case of fulfillment of requirement as an element. And finally, the choices involved in the artificial intelligence adoption cannot be taken for rational and for efficient and for adequate without the exercise of challenging that need a lot more of transparency in knowing what is going on in the design, deployment, and use of these technologies. If we don't ensure that, or you don't state that as an element of the regulation that you are putting in place, there is a high risk of abandoning the protection of fundamental rights, along with abandoning the democratic decision making. Thank you very much.
Muito obrigado, doutora Maria.
Thank you very much, Dr. Maria Canales from Direitos Digitais. Now we'll move on for our fourth and last panelist from our international seminar. We would like to call Dr. Stuart Russell from the University of California, Berkeley. Dr. Stuart Russell is Professor of Science of Computing and Engineering in the University of California, Berkeley, fellow member of the Oxford. His book, Artificial Intelligence, A Modern Approach, with Peter Novick, it became a standard text for the studies on artificial intelligence. It's been translated in 14 languages and it's used in 180 universities in more than 135 countries. His research covers a wide range of subjects related to artificial intelligence and AI on the knowledge planning, decision-making, tracking of several targets, computational physiology and its foundations. Stuart Russell has also worked with the United Nations its current concerns on the threat of autonomous lethal weapons and the long-term future of artificial intelligence, and his relationship with the community. His most recent book, Human Compatible AI and the Problem of Control, from 2019. Professor Stuart Russell, please, it's an honor having you here, and now you have the floor.
Thank you very much, ladies and gentlemen, for the invitation to speak. Breaking with usual tradition in computer science, I will not be using PowerPoint, and I will speak from prepared remarks. So the Brazilian Parliament is to be congratulated on tackling this very difficult but very important issue. You are about to regulate what will probably become the dominant technology of the future, one that may determine the course of human civilization. And I must say that the general principles laid out in the various versions are excellent, particularly the emphasis on human responsibility and oversight. But to get into some details, with regard to the definition of AI as, quote, a computational process that based on a set of human-defined objectives can, by means of data and information processing, learn to perceive and interpret the external environment. There are several points I'd like to make about this. First, as Professor Hildebrandt also mentioned, the requirement that an AI system is one that learns is natural but unrealistic. First, many systems are created by a process of machine learning, but do not learn after sale or deployment. Generally speaking, only the post-deployment system will be subject to regulation, since that is what is sold and used. Different methods of creation may be used, but what matters is the quality and use of the deployed system. Also, many kinds of AI systems do not involve machine learning at any stage. This includes logic-based reasoning systems, such as those that are used by some governments to assess eligibility for benefits, by insurance companies to assess claims, and so on. In fact, the famous Deep Blue system that beat the world chess champion, Garry Kasparov, did not involve machine learning, but no one would doubt that it is an example of artificial intelligence. Second, what really matters for regulation is the fact that an automated system is making a prediction or a decision. We can easily imagine two automated decision systems that produce identical decisions in all cases, but one is using the methods of, quote, artificial intelligence, so it is regulated under this law, and the other, perhaps a lookup table, is not using artificial intelligence, and so it would not be regulated under this law. And this would lead to a method of circumventing the law by converting an AI system into a non-AI system that behaves identically. And third, although it has been the standard approach in AI for many years to begin from fixed human-defined objectives, this is now becoming understood as a mistake. As artificial intelligence moves into the real world, it becomes essentially impossible to define objectives completely and correctly. And a powerful AI system pursuing a fixed but incorrect objective is precisely how humans lose control over our own future. The solution to this problem involves designing what I would call humble AI systems that know that they do not know the true objective to be achieved. This is in fact the technological basis for the safe and beneficial AI systems that the law envisages. But under the current law, such systems would unfortunately fall outside the definition of artificial intelligence. I'd also like to emphasize the issue of fundamental rights, as Dr. Canales did, and its connection to risk-based management. Often we think of high-risk systems as things like X-ray machines and self-driving cars that can cause physical injury or death. But fundamental rights include freedom of thought and the protection of mental integrity. And this implies that information systems, such as social media recommender systems or computer games, that may manipulate one's mental traits, or in the language of the EU Act, cause material distortion of human behavior, these are high-risk systems and must be regulated as such. Now, there is a question as to whether the traditional notion of harm in the laws of liability is applicable here. For example, a person may be manipulated by social media algorithms and may become a dangerous extremist. But that person does not then believe that they have been harmed. And they will be very unlikely to register a complaint about the fact that they are now a dangerous extremist. But suppose we ran a clinical trial of this algorithm and we observe the results. Are the results of this algorithm acceptable? It seems reasonable to propose that if the pre-trial individual indicates in advance that certain changes in mental disposition are unacceptable, for example, they say that they don't want to become a dangerous extremist, but those changes nevertheless occur, then that would be prima facie evidence that the algorithm is distorting and manipulating human beings. On another point, I'm very pleased to see that the proposed law provides for transparency, particularly, quote, about the fact that they are communicating directly with artificial intelligence systems. This is not a minor point. It's essentially a ban on the impersonation of human beings, and it may turn out to be the most important consequence of the new law. At the moment, we feel minor annoyance when we write a complaint by email to a company, and after 2 or 3 exchanges of email, it is abundantly clear that Adriana is just a machine and hasn't understood anything that you've written. In future, it may take months to discover that a friend that you have made in some virtual reality environment, in whom you have confided and whose judgment you have learned to trust, is actually a sales bot who has, by the way, convinced you to buy an overpriced Gucci watch because it's so cool. This is not a speculation. There are startup companies whose business model is exactly this form of deception. Now, human rights and the law are based on the concept of human dignity, and the whole concept is undermined if we cannot tell who is human and who is not. So this rule will become more and more essential for the preservation of human dignity. We owe each other a duty of consideration, and we owe machines nothing at all. Finally, the most fundamental right is the right to life. I think it would be helpful to make explicit that the deployment of algorithms that can decide to kill human beings in the form of lethal autonomous weapons should not be allowed. Thank you for your consideration.
Thank you very much, Professor Russell.
Eu agradeço imensamente.
I would like to thank the generosity of our professors who took part of this first panel, who contributed in a decisive manner for helping us to learn on the tremendous challenges posed by the regulation of artificial intelligence. It's been very kind and generous for your time, despite our delays that perhaps might have compromised future commitments. Now, in order to avoid the delays, now I would like to move on immediately to the second panel that will tackle the challenges on the regulation of artificial intelligence, preparation, analysis on the international experiences. So I would like to call the moderators, Professor Cláudia Leges-Kahn and Cláudia Olivia Marques. Thank you, Minister Ricardo Cueva. So that we don't waste time, we will move on directly to the introductions. We will start with Dr. Irina Korsiki, lawyer from the European Commission of the General Direction. She is the head of the sector of policies on artificial intelligence, and her responsibilities include the regulatory aspects on artificial intelligence. Also, she also had positions on judicial advisory and the right of state supports. Dr. Orsi, thank you very much for your presence, for your availability. I would like to ask you to feel free to start as you wish.
Thank you very much. And thank you very much for having me here this afternoon. This is also very interesting for me. I will share my screen for a presentation and I will explain you here. You should be able to see it now. And I will explain you about the approach of the European Union towards artificial intelligence. You might know that we were the first ones who came forward with a horizontal law last year in April. I'm just trying to move the slide, so sorry if I'm still a bit, here we go. So last year in April, but I start telling you a bit about how we got there. So the European Union has already been supporting, and in that case, the European Commission, so the executive body of the European Union, we have been supporting research in artificial intelligence already since 2004. But then in 2016-17, the issue became the more and more controversial, the more and more political. So we also started to look into policy. And in April 2018, we came forward with the first European strategy on artificial intelligence. This is based on 3 pillars, and the first one is the economics, the innovation, the competitiveness. The second one is the socio-economic, looking into what is the impact on society, and in particular, what is the impact on work. And the third one relates to question of ethics and legal framework. And on that basis, we started working on all these different strands. We were making a call for experts to have a high-level expert group, independent from the Commission. And this high-level expert group developed criteria, requirements for trustworthy artificial intelligence, and also on that basis had an internet-based assessment tool for people developing using artificial intelligence. So this we did start with on the ethics side, and the principles for trustworthy AI this group has developed have been very important for all our future considerations and also for the legal framework I will be talking about in a second. In the same time, we were working always on what we call the excellence side. So we always find that artificial intelligence is good and it needs to be supported. It contributes to innovation, to competitiveness, to our future lives. And in that spirit, we developed together with our member states something we call a coordinated plan with member states. So the Commission, the European Commission and its member states thought about actions we can do individually or together in order to support AI. And here we have plenty of things from skills over the computing capacity, the financing, the research. So all kind of aspects, standardization, ethical questions, which will contribute to an ecosystem of artificial intelligence. And on that basis, we had in 2020 a so-called white paper, where again, we were talking about the ecosystem of trust, so a possible legal framework, and the ecosystem of excellence, so how we can continue to work on this coordinated plan. That we broadly consulted. We got more than 1,500 contributions worldwide, and that then led to the AI package of April last year. So this AI package has a revised coordinated plan. So again, measures on how we can support artificial intelligence, but also the draft legal framework. And this is what I'm going to talk about. Now, just when it comes to the European Union, the Commission, as I said, the executive body proposes something. And this then has to go in the so-called co-legislation procedure. So the member states with the European Council and the European Parliament discuss our proposal. Then they both come to positions on what we proposed. And at the end, the three, the Commission, the Council, and the Parliament, make up their mind and draft together the final text. So what we are doing now, we have proposed it a year ago. The co-legislator and Council and Parliament are discussing the proposal, and we hope to conclude the negotiations sometime next year. What I will be talking about is what the Commission proposed. So first of all, why do we believe that we need to regulate artificial intelligence? The European Union already has a comprehensive legal framework in place, and we have fundamental rights, we have data protection rules, we have consumer protection rules, we have product safety rules, we have anti-discrimination rules, and many others. But artificial intelligence has some specific features in its complexity, opacity, unpredictability, autonomy, and the way it deals with data, which make the application and the enforcement of the existing rules challenging. And there are some risks to safety and fundamental rights. So therefore, we were proposing a tailored regulatory response to mitigate these challenges and to make the current legal framework better enforceable. So this is what our proposal is about. Now, I first talk about what are our foundations, what are the principles. So first of all, we follow a product safety, a harmonization legislation approach. This will probably sound to you very, very strange. It means that, first of all, we want to harmonize the rules throughout Europe. And with the product safety approach, we aim at regulating any artificial intelligence system that is put on the European market or that is used on the European market. So all these systems would have to comply with the same rules. With that, we want to achieve the protection of safety and of fundamental rights. In order to do that, we were choosing a risk-based approach. That means we don't want to regulate the whole technology, but we only want to regulate certain use cases where we believe that there is a particular risk to safety and to fundamental rights. And as I said before, with that, we want to have a global level playing field, meaning that this would apply to all artificial intelligence being used or being put on the European market. It is a horizontal act. That means that it equally applies to all sectors. So there are no specific sectorial rules, but it applies to any artificial intelligence system, again, which is considered to be of high risk. That we want to do in coherence and complementarity with existing legislation. That means, as I said before, we already do have a number of rules in place, and you have to imagine the whole thing as a puzzle. So we want to be part of this legal system. For example, where data protection rules or others are already valid, we want to be coherent with those rules. We want to go, if you want, hand in hand with them. We don't want to override them, but we are complementary. And then the last point, the AI Act is innovation friendly. It is innovation friendly, not only because it is accompanied by the coordinated plan I was talking about before, but also because there are specific provisions about innovation, and in particular about so-called regulatory sandboxes, which means that there are possibilities for companies together with the regulator to develop AI and to make sure that this AI is in compliance with the rules. Now, how does this look? First of all, something I didn't put on a slide now is the definition of artificial intelligence. This is something very, very controversial. The Commission was choosing a very broad definition where we have a general text very much inspired from what the OECD has in its recommendation, but put in more legal terms, and then an annex with certain techniques, and this annex should also be able to be adapted over time. And this is what we consider artificial intelligence. Now, this is very controversial in the negotiations. But as I said before, what is important is what we are going to regulate, and that is mostly the high risk. You have here our pyramid. So you see at the bottom, the minimal or no risk. And these are, according to our estimations, about 80% of all AI systems. We believe there is no risk to safety and fundamental rights. So these can be permitted without restrictions, but we recommend the use of voluntary codes of conduct. Then we have in the yellow category, we have certain applications where we believe that there is a specific transparency risk. So for example, when you are confronted with a chatbot or with a system that assesses your emotional biometric characteristics or categorizes you on the basis of biometric data, or when there are deep fakes, you should be informed about this. So there would be an obligation to inform, and that would be the only obligation unless the application falls also into a high-risk category. To that one, I will come in more detail later. And then you have on top of the pyramid, you have the unacceptable risk. Here we are proposing 4 different categories, 4 different use cases. We have certain manipulative practices and practices on vulnerable groups. We have social scoring by public authorities, and we have biometric systems. So everybody discusses face recognition, but also others, used for the purpose of law enforcement in real time in publicly accessible spaces. These should be prohibited. Stuart Russell just said that he believes that military applications should be prohibited. There should be a red line. We exclude from the scope of our act any applications used exclusively for military. That means that we are not regulating it, but there are international negotiations on it. And we also exclude, because this is excluded from the scope of the competences of the European Commission, any applications for national security. So these are the 2 things we don't have in our act. Now, this is the pyramid. As I said before, the core of it are the high-risk applications. So I'll quickly guide you through those now. First of all, there is an annex where we do have a list of general fields where we have high-risk applications. This includes biometrics, this includes law enforcement, This includes border control, asylum, employment, education, critical infrastructure, judiciary, administration, and certain public and private services. But it's not the whole fields which we would continue to be consider to be high risk. It is only certain applications which are named in an annex. So for example, when we are talking about the public and private services, here we would say credit scoring. This is something with a particular risk to fundamental rights. Or also certain, if you go to the biometrics, we have now remote biometric identification. Or in the field of justice, we have so-called robot judges. We have a list of individual applications. This list should be updated over time when new applications are coming forward. But only this is what we are considering to be of high risk. Now, these high risks, sorry, and I forgot, indeed, this is like the self-standing AI. There is also, we also have products which are already regulated, like machines, like toys, like cars, like medical devices. And these products which are already regulated, there is another list in the annex, and these products are also considered to be high risk. With the difference indeed that the second group, there is already regulation, which means that any assessment of the artificial intelligence can be integrated into an existing assessment of the safety of the product. Whilst for the group I was talking about first, there is no regulation, no assessment yet, which means that the whole thing needs to be newly built up. So the requirements these high risks need to comply with is the use of high quality training, validation, and testing data, relevant and representative for the purpose of the AI, and that indeed in particular to avoid bias and undue discriminations. The second one, to establish documentation and design logging features to ensure traceability and auditability. Then to ensure an appropriate degree of transparency and to provide the users of the AI with the necessary information. As I said before, these rules apply when the AI comes on the market, which means they apply to the provider of the AI. So the user needs to be provided with the relevant information, which goes hand in hand with the risk management process, where also it needs to be clear for the user what needs to be done or not to be done. Then we have human oversight. That depends very much on the system, how this is going to be put in practice, how it is going to be built into the system or implemented by the users. And we have robustness, accuracy, and cybersecurity. So a risk management, all this in light of the intended purpose of the system, and these requirements will be standardized. By the time the act comes into force, there should be standards in place to enable also the providers of the AI to easily apply these requirements. So what we then have is, in order to check that before it's put on the market, there is a conformity assessment for those AI systems which are already subject to regulation. There is already a third-party conformity assessment that would integrate the requirements. For the other standalone products I was talking about before, like in the field of employment, education, law enforcement, there would be what we are proposing, a self-assessment, with the one exception of biometrics, where there would also be a third-party assessment. So this would be pre-market. Then the systems would be registered in a database, and post-market, indeed, there would also be market surveillance to make sure that that the AI really is in compliance, There would be human oversight and monitoring by the users. There would be post-market monitoring by the providers, a reporting system for serious incidents. And if there is a substantial change to the AI system, there would be a reassessment. So governance structure, to conclude, is we have at European level what we proposed to the Commission, European Commission, to act as a secretariat. There would be an artificial intelligence board with 1 member per member state, the data protection supervisor, and then there would also be an expert group advising the Commission and the artificial intelligence board, in particular when it comes to updating or the definition techniques or the different high-risk systems, but also on other things. But mostly the enforcement, what we proposed would be with the national competent authorities, so be the certification, but also the market surveillance. And all this again coordinated by Commission and in particular the Artificial Intelligence Board. And with that, I would like to thank you very much. And I hope I was clear enough and shedding some light on what we are doing. Thank you.
Thank you very much, Dr. Irina Orczyk. We thank you very deeply for this insightful presentation. And we want to ask you if you can share your presentation to the Brazilian Senate, please. Thank you very much. Muito obrigado. E agora passamos então à segunda apresentação.
So now we are going to go on to the second presentation. Is from Professor Indra. Indra Speaker. She's a chair of the Constitutional and Administrative Law, the Information Law, Environment Law, in legal theory of God University of Frankfurt. She is an expert in regulation and digitalization and has given numerous expert advices to governments, companies, NGOs, and courts in Germany and the European Union on data protection, IT security, e-government, platform regulation. She's one of the early analysts of the European proposal on the AI regulation. So please, Professor, the floor is yours.
Thank you very much for having me here. It's a great honor to help to contribute, find a good solution. And Brazil could actually be a trendsetter worldwide and set standards. And I hope very much that I can contribute a little bit to this. What I will comment on is basically the artificial intelligence regulation in the European Union, and I will try to evaluate a little bit what has just been presented, what has been good, and what is something you may actually try to avoid some of the stepstones which are around. Let me start, which I think you've already learned, how vast the use of AI is. We see that presently we have a lege artis HIV treatment with a medication cocktail according to mutations, DNA, and individual behavior, which is something that medical doctors would not be able to prescribe, but only artificial intelligence can actually do that. We see that in research, for example, the CERN physics large collider system has approximately 23,000 hits per minute. That's something that a human mind could not potentially calculate. So that already says a lot about how can we actually follow and control what AI is doing. We have heard a little bit of the downsides, and I'm not going to dwell on that very much, just showing that there might be the linkage, and I will come to back to that shortly. There will be a linkage of some information with other information with AI, which will then lead to results that may not be as desirable as HIV treatment or CERN physics collision. And that is my core essence at the first slide, and that is AI is neither good or bad. It's a technology. It's there to serve humans. And therefore, it depends on its use, and it's, as any technology, a technology with side effects. And the regulation of this use means it's a regulation of the purposes it is used for, And it's not just a regulation, but you also have to look at the enforcement of the regulation so that whatever is the legal rule actually is something that goes deep, and this is, of course, a pun intended, deep into deep learning and into AI systems. Let me, after this small introduction, give you another small background, and I will redistribute a little bit of what you have just heard. Then I will go into the content and assessment, also a little bit variation from what you have heard, and then I will continue with a resume and an outlook of where this could potentially go in Brazil. Let me first start with the background of the AI regulation proposal as such. It is a comprehensive EU strategy, and this EU strategy has a number of regulatory impacts. What we have and what Brazil has wonderfully also introduced is a GDPR approach to protect data and in the long run protect the decisions based on data. We have just presently passed the Digital Services and Digital Market Act, which looks at digital contracts and digital platforms. We have consumer protection law, which is increasingly looking at digitalized applications. It is using information, transparency, fairness, and it has created a large impact through third-party enforcement because consumers are unable to enforce themselves. We do see an increasing anti-discrimination law because we see that we need to control for decisions and for contract closing practices. And also part of this is the Data Act, which is supposed to grant access to and the fair use of information, public information in particular, and also competition and antitrust law, looking at business corporations, have increasingly looked at digitalization. The Facebook case may be something that has reached worldwide knowledge. The AI regulation is part of this entire setting, and it is looking at the results of decisions with a particular quality, and quality being meant neutral, of a technology behind those decisions. The core interest, I would rephrase it, is to regulate power asymmetry in digital services, in digital markets, and in the use of the resources in digitalization. And that is not only that of privates, but also of the state. In the end, what is supposed to be a result is that there is a trust in European data services, markets, and AI system, of course, if and when they are legally operated. Now, oops. Here we go. The GDPR was a standard setting worldwide in the control of data processing. AI regulation may also be standard setting in very special automated decision making. Behind the AI regulation is a particular regulatory approach, and that is the one of prevention, an ex-ante regulation, rather preventing large harm than waiting for the harm to come and then go into a law and order or even liability approach, an ex post approach. That is the typical approach of technology law. That is, we're dealing with uncertainty and risk. We don't know where the technology is leading us, and therefore, in the field of emerging technologies, of fast development, etc., we're trying to slow down the innovation process to a matter that we can still control it. So monitoring is part of this way of controlling and of regulation. The problem that technical law is always trying to solve is one which is very imminent in AI regulation, I feel, and that is the gains of using this technology. They are there, they are immediate, they are precise, they are easy to tackle. The risks, and you are dealing with the risk because you are dealing with the regulatory side, they are often in the future, they are diffuse. And that is something which economists have very, very long discovered, that human beings are not very good in deciding if they are short-term gains and then balancing them with long-side downsides. We have that problem in other fields as well. So regulatory impact here means trying not to look at the short-term and secure gains which are being promised and which are very loud, but rather looking at the risk and accompanying those. This risk-based concept is at the bottom line of the AI regulation, and it differentiates, you have just heard that, between a minimum risk and an unacceptable risk. So the range is rather far, and it has been divided into 4 classifications. And behind this is a technology neutral approach, basically trying to regulate in an abstract way with examples and then with continuous dynamic definitions of risk applications. And that is a very important tool because, as I said, monitoring plays a huge role in technology regulation. You need to considerably and continuously control what's going on, check whether the assumptions are still there, whether the model after which you've built the regulation is still true. Now, what is the content and how do we evaluate it at the present state? Because we are still discussing whether or not this will come true or not. Let me start with the reason why there is an AI regulation. The goal is basically, as I said earlier, the restriction of already existing and developing power asymmetry. And this power asymmetry is huge. If you look at some of those already using AI, we see they have the data, which is the basis. They have the technology, which is on top of the data. And they have as an add-on the services, which then use the data and technology. This is creating closed markets. And the problem behind that is that in the long run, we will have very few having extreme power over the assessment and over the use and application of AI. This is something which is a typical new technology problem, and it has a lot of network effects involved. So this is something that needs to be addressed. Then there needs to be, because some of those AI applications are certainly endangering human understanding, and I just very much, as others in the chat expressed, like that we don't owe technology anything. It's a very nice saying. Basically, what happens is that the regulation takes over. It takes the innovation that is there and then continues the innovation in a human addressing way. And it's a human concept behind that, and actually a humanistic concept behind that. It's technology guidance through law. It's also a means to create rules of the market, of market monitoring, and of market surveillance, and thus create a dynamic standard how to regulate. And all of that is something which I feel is very smartly done, because it's the three big aspects which AI create and which are different from other digitalized technologies. What is a little bit understated is the effective enforcement part, and I will dwell on that in just a minute. And that means if you want to have a rule of law, if you want to have foreseeability, if you want to create an innovation hub, basically, which allows companies to invest, etc., then you need to create exactly that, an effective enforcement, a level playing field, a ground where not some who have the power are treated differently than others. Now, who is addressed? The regulatory, the regulation provision sees actually two addressees, and that is the provider, the one who develops the AI systems, and the user who makes use of them. That is great because we see that the AI regulation has learned from GDPR. GDPR has not addressed the software engineers. That is different now, and that is extremely necessary because it has a direct impact on the development. The problem is, however, that it's mostly private entities addressed. The public is exempted in many instances. And secondly, the individual persons who are controlled, who are potentially manipulated, who are changed, who are the addressees, so to speak, of AI services, they are not addressed and they don't have any rights, although they are supposed to be protected. Now, where is the regulation applicable? And that is, again, an approach which we've seen with the GDPR. Basically, anyone who wants to place this on the market and who uses the results of AI, even if that was processed outside the EU, for someone in the EU. It's a very broad application, and it is very likely to be similar to the market principle we have seen in other European regulation. That is basically the idea that we treat online and offline goods the same. If you want to sell a car to Brazil, you follow the rules of Brazil. If you want to offer a service to Brazil, you follow the rules of Brazil. And that's the concept of the EU here as well. And what is regulated? AI systems. It's a very complicated way of definition, basically a software which is more closely defined, plus a particular purpose, and that is to generate outputs to influence the environment of human beings. That is, again, a very technology-neutral regulation. It gives certain examples, and it allows the Commission, through the Annex 1, to have a positive enumeration. That is a very dynamic standard if the Commission actually pulls forward and monitors closely. The problem here is that an AI system in this sense is not really what computer scientists would understand to be an AI system. It's still a very unclear conception, because if you look back, what really is an output that influences the environment a human being interacts with? That is very difficult to really pinpoint. And finally, we do see that the legal uncertainty has been tried to mend by a dynamics of such annexes. And that's a regulatory tool the EU has not made much use of, but which in technology law is something we always claim that needs to be: close monitoring, continuous change. It would be great if there were cycles involved, how fast they had to change, and also who would have to be involved in those finding of positive lists. How is this done? I'm not going to dwell on this more because you've already heard a lot about this. It's a risk-based approach with 4 classifications. Actually, it's only 3 because number 2 and number 1 are really not in any restrictions. It's recommendations only, a little bit of information. If you don't want to do it, you just don't do it. So basically, it's not regulated. I personally, in my professional view, believe that this is too little, because AI is much, much more. And in particular, if it is something that influences environment and decisions, we have to look a little bit closer. Number 3 is the high risk with high restrictions, in particular, and that's interesting to see, procedural restrictions, not so much material, substantial legal standards which are established, and that might be a little bit problematic. And then we have the unacceptable risk, which is typically forbidden. And this is very brave, stating actually a stop line in a very, very broad sense in the meaning that we are very restrictive here. The lists, the annexes allow, of course, a change from number 4 to number 3, but also from number 3 to number 4. So we do see a risk orientation. We also see that there are not very many clear-cut scenarios that are regulated, and that 2 out of those 4 categories are really emptied. What I would demand and what I would recommend for you to consider is to really have more substantive and material standards rather than procedural standards. And finally, also to look a little bit closer, how do you control for all of that? So how do you establish that an AI that is declared to be designed for a particular purpose is used for that purpose only and not for another one, and that the material the AI uses is really proper? The 4th category, and that's what I'm going to look at together with the 3rd a little bit, is that we do see clear forbidding of what we call dark patterns. And that is great, because for the first time we see that there's the power of the influence of AI systems, of digitalized tools, of technology on thinking, on decision setting, that is really acknowledged. And whether it's direct or indirect, that's why we call it dark patterns. However, of course, the language is still unclear. What type of influence is really meant? Marketing has always been around. Rhetorics is influence. Where is the line between what should be legal and illegal? And does it have to be a central purpose? In regard to enforcement, this will create a ping pong, a table tennis game basically, between the provider and the user. Who is liable, who's responsible, who knows what, who can alter what, etc., etc. And that's something that one should look out for one.
Sorry, I think we lose the sound of the colleague. Acho que perdemos a nossa palestrante. Não sei se a parte de TI pode ajudar, por favor.
I don't know if IT can help. We've lost our professor, the speaker. I suggest we wait a little bit. Let's see if Professor Indra is saying something.
Very sorry about this. Obviously, the AI was listening in and trying to cut me short.
No problem, no problem. Thank you.
Just give me a minute and I'll share my slides again. Here we go. So I hope everything is working. Is it? Good. Sorry.
Yes.
Okay. Exploitation. Let's see whether the AI will kick me out again. Exploitation of vulnerabilities. It's for age and physical mental disability, which I would say is the bottom line. What we see in particular with contracts with access to public and private services of any sort is that there's much more discrimination power. For example, social, economic position, etc. We don't really know what discrimination means in this context. Is it between individuals or is it group-based? Where is the hard line? What is the normative standard of discrimination and differentiation? That's, after all, one of the goodies that we see in IT. And we should look a little bit more on more than just physical and psychological harm. There can be, of course, economic harm and there can be other effects that you are treated detrimentally in access to schooling, to education, things like this. So how do you measure that and how do you deal with causality? Problem here is always, and I'm just going to say this, I'm trying not to say it too often, is the burden of proof. So how do you show actually as someone who is being addressed by AI that this is something that has happened? And it's always a matter of power. And this is on the second level of a power game, basically, because you as a person who is being judged by AI have to find out that you're being judged by AI and how that is the case. How can you do that? None of us, and I would call myself really close to computer scientists, would be able to do that. So social scoring, big debate. China, we all know what that is banned. Very good. Clear message here. We don't want that. We don't want the state and we don't want privates to act that way. Problem, the privates are not actually addressed and neither are platforms, which lacks a huge application. So that's something, look out for that. It's the private sector, but it's also the public sector. And there might be different sets of standards, yes, but both of them have power and they can add to their existing power by adding on AI systems. Finally, the lack of an overall assessment. After all, if AI is used in one particular instance, that's a nice thing to have maybe. But if we have AI around us all the time, those AI systems are maybe interlinked and intertwined, then we need to have a monitoring process and a judgment process which enables us to really look at the whole. And that's something which would be an add-on to the European regulation. Let me just point out for the third category one thing, and that is, again, we have the same structure that the Commission can actively change who is part of this third group with annexes, etc. I listed, you'll have the slides afterwards, a couple of examples of problematic uses. Some of them are highly debated and they do get a certain kind of legalization through that. This risk assessment by the COM is certainly something which creates dynamic and monitoring. But again, we see that we have 1-0 decisions rather than being able to address according to risk within those risky settings, that we look closer at the provisions, at the purposes which are used, etc. And it would be great to have procedural safeguards as well. But we also see that some of those procedural requirements that we have, like creating a risk management standard, etc., are things that create a large burden on small and medium enterprises, which is bad for innovation and also, again, contributes to the power of the big players where we already have a lot of power assembled. So that's something, maybe there should be something like a startup clause. I will show that later. There is actually an experimental, a sandboxing clause in the European regulation in order to take care of that, was one of the big criticisms of the GDPR. Great is, Training data for the first time is being addressed. An AI system is only as good and as bad as its training data. And we know a lot of the biases, discrimination, of the faults actually of AI rely on the bad, not actual training data. It should be more specific though, and it should also give guidance how to deal with it. In order to avoid biases, it's not good to exclude the biased data, but you have to add to the algorithmic system as such. There is transparency requirements, etc., and the user has to get certain information from the provider, etc., etc. Problem is, and I will just like to point out the last sentence here on the slide, that is, it's self-regulatory tools. And self-regulatory tools, sorry to say that, are only as good as there is a strict enforcement behind them. So if there's no control because nobody's controlling that, the self-regulatory tool is really just a piece of paper. It's the shadow of the law that decides whether or not self-regulatory tools really comply with the idea. So I'd personally, professionally be very careful with that. And there's a German saying that you create basically the cow to take care of the garden. And we all know how that ends. And I think the financial crisis of 2008 was a clear sign of how good self-regulatory tools may be to a certain extent. Then also, there is a certain requirement on the user as well. It's not all liability and all requirements and burdened the provider, but the user, the person, the entity, the company using AI has not really much of an excuse anymore, just saying, okay, we don't know how that functions. And that is very important in order to get them into the system as such and feeling that there is a responsibility. So they have monitoring and information duties. It's something where contract lawyers will earn a lot of money with. Again, however, enforcement and burden of proof are not really regulated. And this part, the enforcement part, is really something that could be done better in the EU, and that should be thought together with a regulatory impact. Let me also point out that deep fakes are actively addressed. So we do have some, beyond all of that technological neutrality, some areas where the regulatory proposal actually deals with very concise problems. I would wish for a few more, such as social bots, for example, manipulation of elections. In Brazil, you have social media playing a very, very different part in election campaigns than it does in Europe. I think that's something one might actually look at. There is certainly necessary regulation pending here. There is a bit of other content. One of them are high fines. High fines are great, but if they lack an enforcement mechanism and if there is a big power asymmetry, for example, an enforcement authority with 50 people, including the janitor and the secretaries, and you have the big companies with a legal department of 350 high-paid lawyers, that is not going to create much of a level playing field and will make the fining extremely ineffective, because you have to do a strategic, basically, decision, and strategic decisions on resources means you invest your resources on the small ones and not on the big ones. And that's not where AI is typically going to be a problem, because the big ones are the ones, as I said earlier, who have the data, the technology, and the services. Let me come to a conclusion and outlook. I believe that, and I professionally believe this, so it's not a matter of my Catholic belief actually, that AI regulation in the EU is a super important step towards one of the side effects of digitalization, which have potentially very, very negative effects on democracy, on society, on the development of fairness, etc., etc. The power asymmetry, which is being addressed by it, is a threat to any society. And I'll just name innovation, which is bare and barren if there is power asymmetry, but also of democracy. And that's the backbone in the EU, and that's the backbone in Brazil. It needs a bit of fine-tuning of definitions and of the risks in order to be effective and to really regulate, rather than create a framework under which those who are most risk-prone will prosper and those who are risk-averse will actually refrain from taking part in those markets. The end user, the affected parties have to be integrated. There need to be rights towards the processors and the users, but also towards courts and being in favor of third parties and external effects. And that means you have to strengthen the enforcement, I believe, in order to make AI regulation effective. And I'm not going to talk about all the technicalities of black boxing, white boxing, etc. But I'll strictly restrict myself to the legal side, which I'm the expert on. And that is, any law is only as good as its enforcement tools. And the power asymmetry is based on resources asymmetry. Public enforcement, powerful authorities, procedural safeguards, a burden of proof. That's what we have as legal institutions that we can put into this game and create a level playing field for all involved here. Liability is part of this, and that must be strict. It's a technology law for an emerging technology, and this dynamics behind this technology cannot otherwise be regulated unless you doom a little bit this power and this dynamics. And that also means that you have to have third-party rights, NGOs, also foreign parties, to be strengthened to cope with those external effects, to have access to courts. And finally, sunset legislation is an old hat, as we say in German. It's a very old thing, but it's not functioning well. So this might also be a chance to establish a clear and working monitoring and supervision. The annex situation is good, but it needs to be a bit more specified in order to really control for the developments in the technology. All in all, let me conclude, I believe the GDPR is great, as it's brought Brazil so much closer to Europe that the Brazilian government decided to take this brave step to follow in sync with data protection here. AI, I believe, is the next step because it's looking on the decision side. And we need level playing fields in order for a just world in which everyone has a chance to prosper. And that means that from the economic side, we need that, but we also need it from the human rights side. Thank you very much for your attention. I hope I did not overpass my time, and I wish you all the best and make smart decisions. Thank you very much.
Thank you so much, Professor Speaker, for your brilliant contribution and also very generous in pinpointing exactly where you think are the points the Brazilian process can contribute and further advance in this debate. That is incredibly valuable to the Commission, and we thank you. Então, dando prosseguimento, agradecemos a
Now
professora.
moving on, we would like to thank Professor Indra Speaker for her contribution. And now we'll move on for our third speaker, Dr. Jake Okesho, who's a scholar from Vander, chair of the Law School of the University of Canada, and his PhD research on the challenges in artificial intelligence regulation. He's the member of the Future Globe Scenario and the Economic Worldwide Forum. Without further ado, we'd like to thank you, Dr. Jake, for your contribution, and feel free to start.
Okay, thank you very much. I would like to thank the Juris Commission and the Brazilian Federal Senate for inviting me to this consultation. I am really excited, and I must commend the country for this really big step. This is a little bit of my personal background. I don't think we need to go into that, but I think I might like to start with addressing a few foundational questions when it comes to AI regulation. Dr. Indra spoke excellently about the purpose of AI regulation to both encourage AI and manage associated risk, but also the regulation can play a central role in creating and deploying trustworthy AI that is right-respecting in line with the principles of domestic and international law. And I think it's important that an AI regulation would determine who takes accountability in mitigating the risk and to define liability as well. There's also the opportunity to attract investment, and partnerships. Another question that is foundational is, can AI be fully regulated? And Dr. Irina spoke excellently about this. There is a false narrative surrounding AI that it cannot be fully regulated. And this idea stems partly from the belief that regulations will stifle innovation and can hamper economic potential. But we know that it is the responsibility of Brazil to protect Brazilians and, including people outside Brazil, to ensure that the use of AI does not perpetuate certain dangers or risks. We have seen international cooperation with the GDPR, a harmonized set of rules and regulations. We've seen how AI systems can be regulated by other sister regulations when it comes to like data protection or consumer protection or market competition. So it is not easy to think about regulating a technology that sometimes is not predictable, but yes, algorithms can be regulated and should be regulated. When it comes to the decision about whether soft law or hard law, I think a combination of both hard and soft law is important, given the complexity associated with the evolution of AI. I find that there needs to be some complementarity between both hard and soft law, and I think this is a very important step that Brazil is taking, moving on with this. On the issue of domestic or international law, I also find that there needs to be both. Artificial intelligence is a deterritorial technology. It's not a technology that can be just relegated to a particular state or a particular region. So it needs a bit of both soft, both hard, both domestic, both international. On whether horizontal or vertical approach, I like what Dr. Indra presented when it comes to the EU and the scope of a horizontal approach to it. Whilst there's need for a generalistic regulative approach, there are also values in sectoral approaches as well. So this complex network of top-down measures or bottom-up initiatives, whether it should be binding or non-binding, hard or soft, horizontal or sectoral, these are things that are critical when it comes to AI regulation. I would conclude by saying that the regulation must be flexible. It must be flexible and future-oriented, such that it can guarantee that the Brazilian government is not putting such constraint on the development of the technology, but also it must ensure that it follows the technology as it's fast-growing to guide it in a way that could be beneficial to the people. The last question about which AI regulation model exists, there are like over 21 models. So I like what Dr. Irina talked about, the EU having a product safety and harmonization approach, but also having a risk-based approach to regulate only certain use cases. I find that a balance must be kept between a rigid damage prevention as well as a model that can harmonize interests and offer benefits to all stakeholders in the entire life cycle of the technology. So these foundational questions is just, basically things that you all are very familiar with and has been presented already. But I must commend the country as an AI regulation champion. Brazil is obviously one of the earliest countries in the world with specific legislative proposals on regulating AI. Brazil is also the largest tech sector in Latin America and the Caribbean, hosting 5 of the 9 unicorn companies in the region. And the country ranks first out of the 26 countries in the region when it comes to the Government AI Readiness Index. So there's a lot that the world would love to see and emulate from Brazil. Being a part of the third world myself, I'm very excited about this as a model for African states to follow. I'm going to skip some of these slides, just evaluating the value of the various bills so far. It's good to see from all the drafts a summary that shows some value in what the country has done. The first would be about local and international stakeholder engagement. In fact, this conversation we are having by bringing experts from different parts of the world to talk about how to advance an AI regulation in Brazil is something that is very, very commendable. We find that other Western countries don't seem to engage in this, and therefore they lose like third world insights from like experts from my part of the world. I find that the attempts to make a definition and interpret that definition is quite commendable. I also like the fact that there is a description of the justification for the technology, because we know that our justice system may not really understand how the technology works, but if they understand the value add or the rationale for why Brazil is deploying AI tools or systems, that helps them in understanding how to interpret the sections. The scope of application of AI in Brazil, the complementarity of the laws, the established principles, the reliance on international frameworks, the valorization of work, public trust, and how the bills are pretty much human rights centric and people oriented. I find that these are very, very commendable. Also, the last point about a balanced justification between economic growth, but also social advancement and human rights. So I will make a few recommendations. The first recommendations I will make will be on technical recommendations, more about the drafting process, like the content of the law itself. And the other one would be pretty much organizational or structural, if I can use that term. So I think the first point is about a robust definition of AI and an exception. I know it's very difficult to define AI because AI has, I mean, there's so many ways to define it, and no definition can actually fit the park because what is considered AI keeps shifting, and it's difficult to sort of encapsulate that. But I find that statement about just understanding the scope of that definition, not being limited, is also quite important if it could be stated in the law. I also would like to propose a qualification of the human rights values that are listed therein. So when we say things like privacy, accountability, we need to sometimes explain what we mean. When we say that this law will be rights respecting, what are we referring to? Referring to the Constitution of Brazil, but also to the International Bill of Rights, the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, which are international instruments that Brazil is signatory to. I find that stating this in the legislation helps in enforcing that law as well. I would also like to propose that when we talk about the expansion of privacy protection, we might want to be specific about the use of privacy by design and not by demand, but also explicit mention of who the at-risk groups are when it comes to discrimination, right? There is a specific way that AI would impact the lives of children who may not even know that these technologies are being used on them, or even people living with disabilities, as Dr. Indra had mentioned. As an African scholar, I would also like a replacement of the term neutrality with fairness or equitability. Now, basically, there's no problem with the word neutrality or neutral, but as an ethical standard, it's quite problematic to rely on an ethical value from a machine learning algorithm, for example. This is because in a natural language processing tool, something that might be neutral could be embedded with societal biases that it was built upon. So AI systems hardly ever come from a neutral or objective standpoint. So I think just the language of neutrality gives it this idea that the AI system could not go wrong or do wrong. But enforcing that AI systems and people who build them think about fairness and equitability would be good in terms of, instead of using neutrality as a principle. My fourth suggestion would be about a provision for impact assessment, monitoring, evaluation, and reporting obligations. Maybe periodically, anyone who uses an AI system on Brazilians or in Brazil should provide information about the impact, possibly a human rights impact assessment on how the technology is going, the damages the technologies have made, or the wins, the pros and the cons, and how they're trying to mitigate those risks. I think if that is included in the law, that would be great. The fifth would be about an interpretation section. I know sometimes we use these terms: fairness, explainability, transparency, accountability. What do they really mean? I find that the law could be an opportunity to educate people on the context of these terminologies. And if they can be included, that would go a long way. Another point is about liability expansion. I liked what Dr. Indra mentioned about strict liability, right? But aside what we see in the bill, referencing that liability will lie on the supervisor, I find that, the producer, the developer, the deployer, the investors also have some form of shared liability. And so we must distinguish between what is a product liability versus what is a strict liability. For example, I think in New Zealand, they have what they call a no fault, no liability compensation, where if an AI system does something wrong, the government can sort of pay compensation without sort of laying fault to a company. That way, it doesn't stifle innovation. So my proposal is for an expansion on a liability framework when it comes to the use of AI. Another point would be on the need for a balanced projection. And I think Dr. Maria Canales made a good presentation on that when she looked at the human rights framework. We need to sort of taper down on the techno-heroism of what AI can do, As an African, I would say that it would be important for to sort of reflect on Brazil's history and how previous technologies have been able to impact on people in such a way that we can prevent algorithmic colonialism or AI imperialism, understanding that, you know, AI might not necessarily do all the great things it sets to do. It's good to make that balance to cut down on an overpromise. I find that a lot of the principles already, in fact, there's a proliferation of AI principles, AI for good, you know, all these recommendations, and I find that they can be included or referenced. For example, UNESCO's recommendation on AI for children. There was a presentation here on the UN Human Rights Resolution, or the WHO guidance on AI for healthcare. I find that these actually help, and there's no need to be repetitive with that. The ninth point about guardrails, I would like to propose to Brazil that it can include testing AI systems for bias. And I mean, knowing fully well that minority and marginalized people, or people who are Black, or people who are living with disabilities, or LGBTQ people might sometimes experience bias from the use of this system. And so the government might want to include in its legislation a debiasing order or a testing system. Again, bias is not something that can ever be eliminated, but it can be managed. So the tooling for fairness, the use of counterfactuals, is something that the law can actually put in place as a guardrail. My last point would be about the alignment with supranational rights respecting AI standards and a human-centric approach to data governance, which Brazil is definitely doing and doing very well. So those are my suggestions in terms of the technical. In terms of structural and organizational recommendation, the first would be the existence of an intercoordinating agency. Of course, there are various agencies that we deal with AI directly or indirectly, but if there is some intercoordinating agency with a mandate on the AI regulation and to seeing how that regulation is being kept, that would be great. If possible, an ombudsman to follow with it. The second would be, because AI would affect like immigration or healthcare or like transportation, the chief information officers in those agencies could also be mandated to report on what areas that AI is being used from their own sector in terms of providing regulatory oversight. I also find that government co-regulation, as a third point, with private sector, with academia, with external and internal, which Brazil is already doing, seems quite valuable. Of course, public expert periodic open consultation. The fifth point is about an assessment of Brazil's strategic priorities, strengths, and weaknesses. I find that when we propose laws, we sometimes miss out on some of these foundational requirements. You know, Brazil has unique demographic needs. It has unique strategic priorities, because a lot of countries are going to copy this law from Brazil and use in their countries. It would help them give a lot of background about urgent concerns or resource constraints for the deployment of AI systems across the country. For example, I know that in Latin America, 55% of households don't have access to broadband internet. So a strategic priority could be establishing some of these physical structures that we aid the use of AI in certain spaces. Another concern would be about the use of AI systems for some key sectors. While the EU has like risk-based approach and they classify these risks, in some part of the world, it's not easy to delineate risk in that regard. So you might want to specify certain sectors that would require a lot more criticality, towards determining the use of AI in those spaces. For example, predictive policing is a method of like deploying law enforcement resources to use data-driven analytics, and we find that a technology that would be used in Brazil should not substitute community engagement when it comes to like crime reduction measures. So any AI system at all that will be used to create profiles of Brazilians or identify people that are likely to commit a crime or flag individuals due to their travel history can be prejudicial and would derogate from the constitutional standard and the presumption of innocence. So I find that when it comes to issues around like immigration or national security or law enforcement, we must be very critical about the use of AI in those systems. People have said, don't even use them there, but if they have to be used, they have to be managed, and you must have like a human in the loop. The last point will be about prioritizing local AI and ensuring a transparent procurement process for AI systems from abroad. Now, Brazil is one of the most technologically advanced countries in Latin America and the Caribbean as well, but many technological software used in the country would also be imported. So it's important to note that some AI systems operating in the country will be adopted or hosted from abroad. So it goes without saying that local AI systems need to be promoted. The local ones, like in Sao Paulo, like the ones that are maybe not of standard, can actually be helped and promoted and prioritized, because when they're homegrown and they're localized, chances that they were trained on local data, chances that they will be less biased. I'm just saying, in terms of even economic development, it's important to not only support local technology, but also be a bit critical about the importation or the deployment of AI technology from other countries, especially when you want to create a level playing field and to ensure interoperability of AI solutions, to ensure that it's open licensing terms to avoid things like vendor lock-in. So those are my proposals and my propositions, and I hope they somehow they were able to provide some form of value. But I want to thank you once again for inviting me to this. I commend the really brilliant work that you're doing. I'm really impressed by the Jurist Commission and the Brazilian Federal Senate, and the world is waiting to sort of copy and follow your footsteps in this regard. Thank you.
Thank you, Dr. Jake Ifudu. It was really a wonderful presentation with valuable inputs. We thank you very much. And please share your presentation to the Brazilian Senate. Muito obrigado, Dr.
Thank you, Dr. Jake Ifudu. Now we'll move on to our last presenter of the evening, Professor Dr. Hans Miklitz, Professor of Economic Law from Robert Schuman Center of Advanced Studies of the European University Center in Florence, Italy. Professor Hans Miklitz is one of the pioneers on the whole contour of consumer policy, and he publishes constantly on the internal impacts of the European regulation on private law and private worldwide law. His papers on international law, computing rights, legal theory, and above all, the protection of the consumer on its vulnerabilities are used by all of us, and we are anxious to hear Dr. Hans Miklitz.
Thank you very much. Thank you so much for giving me the opportunity to contribute to this wonderful occasion. I will build my presentation, and I have the opportunity that I can build it on my previous speakers who have introduced the European framework, have commented it, and then enlarged it into a whole set of recommendations that are on the table. My focus will be on the consumer perspective. And what is interesting here is the interaction between the Brazil on the one side and the EU on the other side. In the EU, the whole consumer law is very much built on the market. It's very much based on the idea that consumers have rights to protect their economic interests. I think what the EU can learn from Brazil is that the tradition is different. When Brazil introduced consumer law, it had a strong constitutional background, a democratic background, and consumer law in Brazil reaches far into the society. And I think that is important because what we are currently discussing is not only regulating the economy or the digital economy. What the EU wants to do and aims to do is also in a way to build the digital society for the decades to come. Yeah. I think consumer law and this perspective is important, and it's one of the big flaws. I think it has been highlighted before, but the big flaw in the whole discussion in Europe is on all the different projects and on the AI Act in particular, is that the consumer perspective is missing. It is just not there. So that is strange in light of the simple fact that in the EU, I don't know the figures from Brazil, but in the EU, much more than 50% of the gross income results from private consumption. So how can you then forget about it? That in the end, private consumption is what really matters in our consumption societies. I will present, and maybe, I don't know, I'm unable technically to share my screen. I don't know whether it's possible to, I send a PowerPoint, whether that can be shared with you. Otherwise, I speak freely and you send it around. That's not a problem. The purpose, what I would like to do is to give you, let's say, a state of the art where we are standing in Europe when it comes to consumer protection and regulation and AI. And then to discuss, present the particular projects of the European Commission before I go to the more academic perspective. So let me start with where we are standing today. As I said, and please don't forget it, as I said, the EU approach by now has simply not had the consumer dimension on the plate. The logic behind was, that has changed in the last year, I think, but it was originally that the existing body of consumer law suffices to deal with all relevant issues. So GDPR has a strong overlap with consumer protection. I will not go into this. I will go to the mainland of consumer protection rules in the EU, and that is in the field that we are discussing, mainly the unfair commercial practices law, which has an extremely broad scope of application and which covers the let's say the old and the new economy. That is clear. It means in practical terms that it covers also data privacy policies. The European Commission published in December 29 guidelines on the interpretation on how the famous dark patterns could be dealt with under the current regime, but these guidelines are non-binding, as I said, and they have no impact on what the European Court of Justice or what national courts are doing or what public enforcement authorities are doing. The structure of the Unfair Commercial Practice Directive looks like this. You need blacklisted practices that are always forbidden. Then you have aggressive practices, which are mainly, and here is the link to undue influence. One of these aggressive practices defined in the directive as undue influence. And then you have misleading action and misleading omissions as the classical category of unfair commercial practices law, combined to a general fairness test on the bottom. The EU law distinguishes between two groups of consumers. So one group is the average consumer, and the other one is the vulnerable consumer. And I think Ina has already explained what a vulnerable consumer in the EU context means. It says that, thank you, can we move, exactly, can we move to the vulnerable consumer? Yes, so the vulnerable consumer is the one that suffers from, let's say, mental or physical health problems, or is then the old consumer or the young consumer, and the more general criterion is credulity. So far, this distinction has not really mattered. That's where we are standing. And it's important to for us, because also in the AI Act, in the proposal that we have seen and talked about, again, this narrow concept of vulnerability shows up, and legally speaking, it cannot be enlarged. It's very difficult to enlarge it because it's always this average consumer concept that is dominating. Could we please move on to the next slide? So what I will do now is to report a little bit on the inner machinery of the EU. It's not only the AI Act that is of importance for consumers, but it's also the Digital Services Act. The Digital Services Act is amending and partly replacing the e-commerce directive. The e-commerce directive was adopted in 2000. And in 2000, for 22 years, it was not amended, and it defined the legal frame for 20 years under which all the companies were operating that are now in the limelight, and how the internet worked, and how all these commercial practices worked, on how the advertising operated, on how the cookies operated, on how advertising was personalized, and so on. All this happened under the e-commerce directive. And that is going to be changed, and this Digital Services Act is quite advanced. So that means there is a political agreement between the various EU institutions, and it will probably be adopted before or after the summer. And under strong lobbying from consumer advocates, there were 2 rules introduced. Please don't take this too seriously. This is all preliminary, yeah? So when you can spread it around, but it's still not final. It's just, let's say, it's reform, and it's not the final wording. There might be some changes. But what's important is that in the Article 23A, you have a rule that providers of online platforms shall not design, as it said, organize or operate their online interfaces in a way that deceives, manipulates, or otherwise materially distorts or impairs the ability of recipients to make free and informed decisions. So that is, in a way, a language which strongly overlaps with the Commercial Practices Directive. And that is why the second paragraph is a tricky one, and from a consumer perspective, a very problematic one. Because it clearly says, this paragraph 2 that was introduced in the negotiations, that this wording that I just read, and that would give the Unfair Commercial Practice Directive a kind of a digital outlook, applies only as long as a certain practice is not covered by the Unfair Commercial Practices Directive and or by the EU Data Protection Regulation. So that means in practice, it's of very limited importance. And there is still a strong fight to what extent this wording can be amended, but it also means, to put it positively, that the focus should be put on to what extent the Unfair Commercial Practices Directive needs to be amended. Next slide, please. Could I see the next slide, please? So again, this is in the Digital Service Directive. It regulates compliance by design. We discussed this a number of times. Here we have no limitation. I mean, there is no clarification or no limitation in the sense that the rule introduced will not be applicable if the same strategy comes under the Unfair Commercial Practice Directive or data protection regulation. I'm stressing this point, and I cannot, in whatever Brazil is looking for, I cannot stress the point often enough, but it is very important that Brazil takes a holistic approach, and that it takes all the potential overlapping and mismatchings into account, so that consumer protection rules do not go lost within these overlapping and underlappings different regulations that you have also. Let us move on, please, now to what the EU has in mind in the next slide. I mentioned already the Artificial Intelligence Act. I will not go into this again. Just the unfuture of the Artificial Intelligence Act and what has been presented here and discussed is totally unclear. There are 4,000 comments and recommendations for amendments under discussion, 4,000. And it's not at all clear how the next version or a revised version will look like. That is subject to a political battle between the various EU institutions. And it's open. There's also strong resistance against this risk-based approach. There's also a serious discussion on whether it's not better to just focus on particular risky practices that should be prohibited instead of regulating AI as a whole, because we have no certainty, as has been said, of what AI really means. What is equally pending, and that is, I think, crucial from not only from a consumer perspective, but from the society, that is the question of strict liability, of whether there should be particular rules on, take the example of self-driving cars, who is responsible in case of an accident. Here, the European Parliament, in a way, is in the driver's seat. It has set up a working group, and this working group has elaborated proposals, but so far there is not yet a proposal from the European Commission. And please recall what has been said already today. The European Commission has the monopole to introduce a proposal, so we are waiting for an initiative from the European Commission, and by now it's not clear how it will look like. Next slide, please. Under these lobbying activities, in more or less very shorthand, but that is a big success for for the consumer organizations, but much broader for the consumer lawyers, for governments who were supporting these ideas. The European Commission decided to start a digital fairness check. That means what has been left out in the last 10 years that has been presented is now on the table. It is the question whether the existing body of consumer law rules, mainly unfair terms, commercial practices, and consumer rights, information rights, should be amended. But two problems here, two huge problems. The data protection regulation is not integrated. And again, I refer and I agree with Ina Speaker, what she insisted on. Consumer law enforcement is also not explicitly included. And everything depends on enforcement. I will not stress this again. The process is here totally open and under discussion. So currently the European Commission is calling for evidence. Then there will be a public consultation. And last but not least, then after the consultation, the European Commission will have to decide whether it comes up with a proposal for amending the current consumer law acquis, the directive on unfair terms, or the directive on commercial practices, or consumer right. But please, this is open. The simple fact that the European Commission initiated the digital fairness check does not necessarily mean that there will be new consumer law. It also means that Brazil still has the chance to be the first mover here in the field. My last part is now to report a little bit on the academic discussion that we had, and perhaps the last slide, please. So it is a study that was initiated by the European consumer organization BERG. It was not paid for by the European Commission. It was an externally funded project by a foundation, and there were a number of people working on it. I was one of the authors. You find here the two references. The first was discussing the concept of digital vulnerability, which I will explain in a few minutes. And the second is discussing the regulatory gaps in this huge amount of rules that the European Commission has been proposing, and to some extent, we have already discussed them. Next slide, please. Let me focus here on digital vulnerability now. These, the authors of the study that I was referring to in the previous slide were not only lawyers. We had a legal philosopher with us, and we had also somebody from communication theory with us, and specialists in digital, in data protection law, and empiricists. So what we wanted to know and to discuss, and what was our question, and in the way was also the finding, is what does digital vulnerability mean? And should we not, let's say, turn here the perspective upside down and accept that we are all digital vulnerable, that vulnerability is a cross-cutting concept, a universal concept, even more so in the digital environment, where we are confronted with the technology that we do not overlook. Let me give you just one example out of the many that I could mention. Think of the famous consent. Yeah, so we are all asked to consent to something where we do not overlook the consequences. Realistically speaking, only a strong minority of people, of citizens, perhaps 5%, that means those who are in the information technology, they are really in a position to assess or to have an idea to what they consent. But 95% of us, even the consumer lawyers, even let's say, if I see Claudia before me or me, we are not overlooking what we should consent to. Yeah, if we are not helped by computer scientists or by people who are really working in the field, or if we cooperate with them, we cannot understand it. So that is the first study, and the major message here is, let us really rediscuss that vulnerability is something which is situational, or which is only affecting the old and the young ones, or the ill ones. You know, no, it's, I think, universal, and that is what makes the digitization of the economy and society so particular, and where there is really a new step in our development of capitalism, or of our society, so to say. Next slide, please. What are the normative consequences now? And we translated it, and the proposal is not to use vulnerability, but to use a different terminology. Why? Because vulnerability, the vulnerable consumer, is a loaded term. It has already a particular meaning, but digital asymmetry hasn't. And in our concept that we proposed, we put the focus on the structural dimension. Yeah, it is not an individual deficiency or an educational gap that we do not understand the technology that we are handling. It's a structural element. Yeah, it's inbuilt into the technology. And the second element is relational. What do we mean by relational? We are using Google for 20 years now. Yeah, that is the typical phenomenon of a relational contract that we have with Google, or with Amazon, or with whomever. It's more or less a lifelong commitment, unless these companies are going bankrupt or are bought by somebody else. So, and that means the big players, the GAFAs, yeah, Google, Amazon, Facebook, Apple, or Metaverse now, they know us for many, many years, and they have data about us, what I summarize in the language of the alter ego. Each of us has an alter ego in the net. Yeah, Claudia has one and I have one. Unfortunately, we do not know exactly what they know about us, but they know a lot about us. And the last one is the informational asymmetry. And that's, we have included it because we have to be realistic, and because of the 5% that may understand as lawyers, we should be, let's say, realistic, fair, and rational, and that's why we included also the informational asymmetry here. In the last slide now, I propose, could you go on for the last slide, please? It's a bit too small in my slide, but it's not so important. It's mainly a translation of what I am saying in a concrete proposal that Berg is now introducing and spreading into via all its channels into the political debate. That means this focus on structural, relational, and informational digital asymmetry, which should be the focus. And we should move away from this idea that we are in a position as consumers or as citizens to handle the technology. And last point here, and the most provocative that also came up, but we deliberately integrated it into our proposal, is a reversal of the burden of proof. It is not for the authorities to show that a certain advertisement strategy is leading to manipulations. It is the opposite. Those who are using the technology have to show that they are not misleading, manipulating, or exercising undue influence on the consumer. I think we all know as lawyers, burden of proof is the trick that solves many, many problems. And we would like to initiate here a debate with our proposal on how to find a shared burden of the proof, because otherwise we will end up in wonderful rules at the very best that nobody can implement. Thank you very much for the occasion. I wish you good luck for your project, and I do hope that Brazil takes the lead and that you are the first mover. Thank you.
Thank you so much, Professor Miklas, for your valuable contribution. I will now hand it over to the President, Ministro Ricardo Cueva. Muito obrigada, Professor Miklas.
Agradeço aos palestrantes pelas valiosas contribuições ao nosso debate.
I thank all of the speakers for the great debate, for all the so opportune insights that are for us here in Brazil. So for now, I suspend our work and we'll be back at 14 hours for panel number 3. Thank you so much to all of you.